Thank you for so many of you attending. We're very excited to present and discuss with you the interesting area of Nebraska adoption law. I want to welcome all of those who are present via the internet and all of you who are present here in person. Some of you have written materials, some of you do not, some of you printed them out. We'll be referring to specific page numbers of the manual and the handout as the different presenters present. So stop me if I'm moving too fast to get to the different pages. If you're trying to scroll on the computer, it may take you a little bit longer than it takes on paper. I want to thank all of our presenters today for being willing to come share their experience and wisdom with you. And I want to thank you all for being here. I want to make sure you know that if you need a wireless Wi-Fi connection, you select the meeting rooms network and enter Cornhusker Meeting, all one word. Cornhusker Meeting, all one word. So that will get you on the Wi-Fi for free here. All right, we are going to start on time so that we can end on time. I want to handle this a little bit informally, so if we get to a point where you have a burning question, just raise your hand and I'll try to see it and respond, and we can take the conversation where you want to take it and have it be as helpful as possible. How many of you are here for the mindset of guardian ad litem? Okay, good to know. I will try to think about what we're talking about in that context as often as possible, and then you stop me and say, Susan, what about in juvenile court? What does this look like there? And I may or may not be able to answer that question, but we'll figure out the answers together. For those of you who have not met, I'm Susan Sapp. I've been practicing at Klein Williams for about years, and during that time I've had the pleasure and honor of being involved in hundreds of adoption scenarios, usually representing birth parents, often representing adoptive parents. Most frequently anymore, they're interstate adoptions that cross state lines, and those are particularly interesting and fun to mesh two unmeshable sets of laws across state lines. So we'll talk a little bit about that today, but that gets a little bit more complicated, and so we'll dig in as deeply as we can in my presentation, but then we'll look forward to Deanna Brakhage from Health and Human Services giving you all the details on how to make the Interstate Compact Office happy with what you submit on an interstate place. So we'll also hear from Jim Anderson, who is with the Nebraska Children's Home, who will tell you what to expect and have your clients expect regarding homesteading. Why is it done? How is it done? Under what circumstances is it done? What should they expect? What would cause someone to not be approved or be approved for a homesteading? And then we'll also hear latest technology on finding birth fathers, how to file an international adoption finalization, and we'll hear some special issues as it relates to state wards. So buckle up, and we will start heading through some of the basics and overview. So the first session is kind of mixed together. We're going to do an introduction and talk about some adoption law basics, and then we're going to segue into understanding birth father rights and notice obligations. Okay, so you need to know right off the bat, adoption is a creature of statute, and I am on page 1 of the manual, the first section of your materials, Understanding Adoption Nebraska. After the table of contents, you'll find page 1. Adoption is a creature of statute. You have to read the statutes in their entirety. They have to be strictly followed in order for an adoption to be legally valid. So take the time to read them, understand them. I once had a judge tell me, they make sense if you read them from the front to the back, but if you read them back to the front, they don't make sense. I don't know what he meant by that, but read them front to back. They do make sense that way. Understand what adoption does to a relationship between biological parents and child. Birth parents other than through intestate succession. All right, so let's go to page 2. You've got clients coming in. Maybe they're adoptive parents, maybe they're birth parents. Anymore, adoptive parents and birth parents have matched themselves up before they ever get to my office. It used to be word of mouth. It used to be papers handed out. It used to be newspaper advertisements and the want ads. It really doesn't happen anymore. The internet dominates most of that finding and facilitating and matchmaking. I don't do any of that really anymore. Facilitators are not agencies. Facilitators are groups, usually out of California, who are unlicensed, who do the matchmaking. I've worked with some who do a very nice job. I've worked with some who I didn't think did a very nice job. And they vet the birth parents, and they try to find out if there's really a pregnancy. They try to find out if this person's really serious, what's going on with the birth father situation, and then they help the birth mother find a family. And so they typically never get those. But when you're talking to folks about adoption, you want to start and explain from the get-go that you may be hired to file a petition for adoption after the placement, or you may be hired to do the initial placement. Information you need to find out is if people were married, if they were not married. Has there been abandonment? How old is this child? Has there been a marriage and a divorce? Has there been an adjudication? Has there been any kind of familial relationship? Older children adoption are more difficult than infant adoption because the complexities with the birth father get much more significant. If the biological parents were never married, then you need to know that the statutes that govern out of wedlock births are 43104 to 43104.25. We'll talk about unwed father rights in a little bit, but that's the basic information you've got to get is the lay of the land, the legal relationships of different. When we're talking about step-parent adoptions later in the afternoon, we'll also talk about assisted reproduction. Tollefsen will be here and talk to you about all the technology a little bit, and how you need to ask questions as to how children got here. If you ask, or there's a question to ask after that though, did the artificial insemination occur at a clinic? Was there a sperm donation? Because sometimes what you'll hear is that there was something much less informal that went on with a turkey baster or whatever, and there was a pregnancy achieved, but you're not going to be able to get a certificate from a clinic as to the sperm donor because it was done at home informally. Well, then you still have a birth father you've got to deal with whose rights need to be addressed. So always ask enough questions. I've asked more people about their sex life than I've asked anything in the scope of my entire life. And you've got to get comfortable asking difficult questions and nosy questions, but it's not the first thing you ask. You don't just say, hello, I'm Susan Sapp, who would you sleep with? It doesn't really go that way. You've got to establish a rapport. You've got to ask big picture questions and get to know this person as a person, whether it's the adoptive parents or it's the biological parents. Sometimes they come in together, sometimes they come in separately, sometimes you've got a birth father there who might be the actual father or might not be. And so you've got to get the lay of the land without insulting anybody. Is this person to be adopted a minor? That's an important question. Are the people seeking to adopt married? Are the people seeking to adopt over age 19? A non-married person cannot adopt the legal child of another non-married individual unless the first legal parent relinquishes their rights. We know from In Re Luke, and I'm on page 3 of our outline, In Re Luke from 2002, that unmarried people can't adopt together, and you can't do a co-parent adoption of unmarried people. That came up in the same-sex setting back in Re Luke, but now since the legalization of same-sex marriage, step-parent adoptions can be done for same-sex couples if they're legally married. But still, two unmarried people cannot adopt jointly. That's still true. I want to just point you to page 97, page 104, and page 109 in your outline. Those are documents that I use in my practice to do interviews with incoming clients so I can get the lay of the land. You'll see that there's, on page 97, there's a birth mother marital history and father identification. It asks some of the same questions as the birth mother interview form, but it asks them from a different angle, from a different take on things, so you can get the best and most complete information. And the conversation about putative fathers is not a one-time conversation. It's an ongoing conversation in the course of your relationship with the birth mom. Sometimes the birth moms are dealing with difficult situations, and it's difficult for them to tell somebody they don't know well some of the circumstances of the possible conception. Page 104 is a birth mother interview form that I use, and you'll note that it has a place for the birth mom to sign and notarize. So I do the interview, I have it typed up, and then present it to her to review again and make sure that information is correct. And she signs in front of a notary. Also, note on 108, page 108, I explained to her the attorney-client privilege. I explained to her the importance of sharing information with the adoptive parents, especially as it relates to medical risks or drug usage or sexually transmitted diseases that might affect the delivery. Like if somebody has herpes and they deliver a baby with open herpes, you've got huge neurological problems that can result. Those kinds of things need to be shared with adoptive parents. But I have the birth mom identify on page 108 any information that she is unwilling to allow me to share. And if it has something to do with the health or prospective health of the child, then she and I are going to have to negotiate that. And I have on one occasion withdrawn from representing birth mom who was not willing to allow me to tell the adoptive parents that the child had been exposed to methamphetamine in utero. I'm not going to keep that information from anybody anytime. And so I had to withdraw. And in the end, that information was shared and it got solved. But you can't, in my view, be complicit with keeping that kind of necessary information from the people pursuing the adoption. And last, on page 109, you'll see the affidavit of identification. This is the form affidavit of identification that is required in every single adoption that you do, step parent, newborn, juvenile court, anywhere you've got to do an affidavit of identification. Sometimes you don't have a person available to do the affidavit of identification. We have on a few occasions had birth mom abandon the child, and birth mom was not available to do the affidavit of identification. So under the statutes, the courts are looking for substantial compliance with the statutes. In that case, we had a caseworker who had worked closely with the birth mother, and the birth mother had shared information about the birth father suspect with her. So we had the caseworker do the affidavit because we couldn't find birth mom, which was the whole problem and where we were having to pursue termination through abandonment. So get the best person you have. If it's a juvenile court case and birth mom's rights have been terminated, she may not be very helpful to you in filling out an affidavit of identification. So it may be an HHS caseworker. It might be a guardian ad litem who has the best information. It might be birth mom's sister who has the best information about who the birth father is. But try to get it from the actual birth mother and get as much detail in there as possible. Just because the form has fill in the blanks from the statutory form doesn't mean there might be times that you need to tell more information about the situation. So be descriptive. Okay, so we know then in order to finalize an adoption, adoptive parents have to be residents of the county where the petition is filed unless there is a military situation and if folks live on a military base, then there's some exceptions. And then also, if the child is under the jurisdiction at that time of a juvenile court, then jurisdiction would remain in that county where the judge has jurisdiction over the child, irrespective of where the adoptive parents live. Then you need to know 43109 says the child has to have lived with the parents for at least 6 months before the adoption decree is entered. Paternity adjudication. That's all available on public record. So if your clients don't know the answer to that, you need to do some due diligence to make sure that you know if there are cases over that child. Note that if a birth father has been adjudicated to be the
muted
in an unmarried situation, so most frequently that's in a paternity case, but it could be in a juvenile court case, could be in a guardianship case. If there's been an adjudication and the court has said that guy's the dad, then you have a special procedure you need to follow in 43104.25. Okay, so one of the best questions to ask early on at the top of page 4 is, will the biological parent consent? Shortest distance between 2 points is if you've got a consenting birth mom and a consenting birth father, and you've got an affidavit of identification from birth mom where she's saying, this is the guy. There's no one else. I don't sleep with anybody else for 6 months before I got pregnant. Anytime during the pregnancy, he's the guy. He's willing to consent. Don't be so busy looking for how to notify this guy and how to deal with his rights without asking and getting his involvement. Children are better off with two consenting birth from that social history and that medical history, and knowing that both biological parents made a decision that this was in the best interest of the child to do an adoption. So don't forget to ask him for consent. Okay, if you're talking about a married situation, then you're looking at, do we have abandonment? Do we have a mother that's abandoned? Do we have a father that's abandoned? Are there other potential birth fathers? Remember that marriage is a legal presumption that the husband is the biological father. I can't tell you the number of times that is not true. They've been estranged, they haven't slept together for 4 years, but nobody's bothered to get the divorce finished. Nobody's had the money to get the divorce finished. Somebody's been in jail. Whatever the impediment is, they aren't together. That is not a in-wedlock birth. It is an out-of-wedlock birth because the biological father is not married to the mom. So you've got to do two things. You've got to deal with the actual birth father, notify him, try to get consent, publish, whatever you've got to do to get notice to him. And then you also need to deal with the fact that you need the consent of the married father, even though he's not the dad. Unless you can get a DNA from the actual dad, the actual biological father, unmarried father, get a DNA from him that shows that he is the biological father, then it's a rebuttable presumption. 98% of the time, the judges have allowed us to not notify married dad or get a consent from married dad when we have DNA showing that unmarried bio dad is the dad. 2% of the time, they've been jumpy about it and they've made us go ahead and notify the married dad or try to get consent. I don't think it's required because there's case law that says it's a presumption, but it's a rebuttable presumption. Yes?
Now, would that work in the contrary rather than getting the DNA from biological dad rather than married dad, get the DNA from the married legal father and exclude him as father?
Yeah, if he was willing to participate in the DNA test to prove that, he's probably willing to sign a consent. So we haven't done that very much because usually if we can find him and he's willing to do that, he'll just sign a consent. It usually says, where do I sign? How fast can I sign? But good idea. You could do the converse. Yeah. Okay. Make sure you find all your birth fathers. Get the affidavit of identification filled out. Get the information from the birth mom on the 3 handles that I talked about. Find out if she was ever legally married to anybody. Sometimes late in the ball game, she'll tell me initially, yeah, I'm not married. And then later, oh, I was married, and we never really got divorced, but I don't consider myself married. Okay, that's still married. So go with that. You need to obtain some basic information, addresses, names, birth dates, medical history, social history. All right, let's go to page 5 and talk about children born out of wedlock private placements. There's a difference between agency placement and private placement in Nebraska. In an agency placement, birth parent relinquishes her rights, birth parent relinquishes his rights to the agency. The agency is the legal custodian of the child during the period of time between placement and finalization. Agency gives legal custody to the right to custody to the adoptive parents, but the agency is still the legal custodian. At the end of the 6-month period, then the agency consents to the adoption, and the adoption is finalized. It doesn't mean that birth mom has an opportunity to change her mind during that time, but it does give the agency the right of legal custody. In a private adoption, birth parents relinquish directly to Bob and Betty adoptive parents. They don't relinquish to me, ever. You wouldn't do that. They relinquish directly to the adoptive parents. The adoptive parents still have to wait 6 months to finalize. It is not a period of time for birth parents to change their mind. Yacht versus Bat and some subsequent cases make it clear that a simple change of mind, even in a private placement, is insufficient. There would have to be proof of duress, coercion. Birth mom does retain the right to have what's called a best interest hearing, but she loses her superior rights as a biological parent. So she could, during that 6 months, come forward and say, I want the baby back, but she would be on equal footing in terms of legal rights with the adoptive parents. So let's say she found out that both the adoptive parents were raging alcoholics. Never happened, I'm just making it up. But let's say she did, and she wanted best interest hearing. She might do better than the two raging alcoholics, and she might get custody under a best interest standard. But most of the time, absent that superior right of a biological parent, the single parent biological mom is not going to be able to undo the adoption. I've never had a best interest hearing requested in 27 years. So my advice to my clients is, you can't change your mind. 2 seconds, 2 minutes, 2 weeks, 2 months from now, you can't change your mind. This is a done deal. You've been advised of your rights. It's voluntary. It's knowing. If you do this, it's done, and there's no revocation period. In an agency placement, there's also no revocation period. That's statutory, and the birth parent's relinquishment to the agency is irrevocable upon the acceptance of the placement by the agency. Both agency placement and private placement are legal in Nebraska, and neither one is right or wrong or better or worse. Sometimes my clients pursue private adoption because they want to design an adoption plan of their own design, or they want to place with the family out of state, or they don't want to do counseling. They have placed before. They're older. There are legitimate reasons that they decide to do private adoption over agency adoption. Okay, so when you get involved in, I prefer the initial contact to be initiated by the birth mother. It's her first voluntary act is contacting me. I don't go call her. I don't get a call from somebody and say, hey, call that gal. She wants to give her baby. I'm not doing that. She can call me if she wants to hire me. Explain attorney-client privilege, get to know her, understand her interests and motivation. Her first and primary right for you to observe and protect is her right to parent the child herself. You should never be in a position where you're meeting with a birth parent to try to get her to give a baby up to these other people. That's not your role. It's never your role. Only she has the absolute right to place for adoption, and she's not committed to place just because she's selected the family or because she's cultivated a relationship or because she's told them she intends to place. She cannot be bound in any way to pursue an adoption plan until she signs relinquishments, and she cannot sign relinquishments until 48 hours after birth at the soonest. Can't emphasize that enough. You can't take a relinquishment pre-birth. You can't take a relinquishment any sooner than 48 hours after birth, period. No exceptions. Okay. She needs to be informed of her right to go through an agency versus a private adoption. You can explain that one benefit of agency adoption is in-house counseling. I customarily advise all my clients that they almost have to, in my view, pursue counseling. I can't physically make them and drag them, but I do tell them I feel very strongly about it. It's your job to help them locate counseling, to provide it at no cost to them. If they've got Medicaid, you can work with a Medicaid provider. If not, the adoptive parents can pay for that. But it's very important and appropriate for them to have counseling. Not you, a real counselor, not us. With the exception of some folks, we're not trained mental health care providers. We might have done a lot of adoptions. We might have been in the situation personally, but you're not a counselor. You're the lawyer. So get them to a counselor with the appropriate degrees and preferably somebody who has an understanding of adoption. All right, let's go to home studies. We'll learn more about that from Kim Anderson. All home studies, all adoptions require home studies. 43-107 is something you should read carefully. If it's a newborn adoption, it requires a home study. Pre-placement, it means it needs to be finished pre-placement. If the child is in the home for reasons other than adoption, then agencies will typically do the adoption with the child already in the home. But don't play games on that. Don't like do a POA or an intended adoption and then have them do the home study after the fact. Kids who are in foster care, they can do the home study when the child is already in the home because the child came into the home for purposes other than adoption. There is a bill pending, LB 684, that would no longer require home studies if the adopting parents were the grandparents of the child. So keep an eye on LB 684. Okay, let's go to openness. Page 259, I want to bring to your attention a a special issue on the area of adoption, or open adoption. Our Supreme Court in May reinforced the fact that open adoptions do not exist in Nebraska, except in the case of adoption of state wards, in which case there's already a statute. That's the Monty and Teresa case versus Jason and Rebecca. The court held that a consenting biological parent can challenge the validity of a relinquishment on the basis that it was not voluntarily given if there was an agreement between the adopting parents and the biological parents to retain some category of rights, including those to communication, contact, or visitation. There are some facts in this case that probably are in dispute, but I'm just going to tell you what the reported decision says about it, and those may or may not be different people's understanding of what happened actually. But what the court found is that that Monty and Teresa agreed to have a baby supposedly for the specific purpose of providing a baby for Jason and Rebecca, who were unable to have children. The case says that they agreed that this would be kind of an open, a very open adoption, and they envisioned something more akin to co-parenting, not really adoption. Adoption is a complete severing of rights, and all the rights vest with the adoptive parents. Here, the decision says that they were contemplating this co-parenting. Monty and Teresa were not represented by counsel. It is my opinion that is a breach of the duty of an attorney to take a relinquishment for adoption from a birth parent who is unrepresented by an attorney. If you are the attorney for the adoptive parents, you should not be the person taking the relinquishment from the biological parents. You should always bring in a separate attorney to do that. There is no way in the world, if there's allegations of duress or coercion or lies or whatever, there's no way for you to prove that they were properly advised of the meaning of the relinquishment, and I just think it creates an unstable adoption. So in this particular case, Monty and Teresa were unrepresented. They claim that that they were not advised of anything. They claim that they were told these were temporary relinquishment documents. They claim they were not told anything about open adoption, that they were promised all this contact, et cetera, et cetera. Whether that's true or not, that's their claim after the fact, and you can't disprove it because they didn't have separate counsel. So in any event, the court held that retention of some parental rights, even however slight, is sufficient to invalidate the relinquishments on the basis of duress and coercion. So this was a private adoption case. The rationale applies to agency adoption. Until this issue gets addressed by the legislature, I've advised to put some very strong language in the relinquishment. You'll find it at the bottom of page 259. It starts with, I realize that although the adoptive parents and I may have discussed possible future personal contact between the child and me, et cetera, et cetera, et cetera. It's horrible language. I hate it. But it is absolutely trying to cover in every way, shape, and form that they know that even if they've been promised the moon in terms of contact, monthly visits or weekend visits or whatever might have been promised to them, that it's not valid, it's not enforceable, they can't do the adoption, and they're not relying on it. LB 744 is pending, and it would create the existence of open adoption in Nebraska. The version of 744 that's pending does not have civil court enforcement of communication and contact agreements like the state adoption statute. The rationale for that is twofold. In adoption, it's supposed to be a cooperative relationship between the adoptive parents and the birth parents for the benefit of the child. The birth parents are supposed to be relinquishing all of their rights to the adoptive parents to make all the decisions for what's best for this child. The retention of rights and a court enforcement relationship or potential relationship there is inconsistent with that cooperative triad of adoption. Second, if you have state wards, there's almost always an existing relationship with the birth parents or the extended family that isn't in place in a newborn adoption. So you'll see that difference in LB 744 as it compares to the state ward adoption. That hearing is on the 22nd if anybody is interested in testifying. So hang loose, but in the meantime, put this horrible language at the bottom of 259 into your relinquishments, and make sure that you emphasize and get in writing in your birth parent interview that you've explained the limitations of openness to your clients before they sign. Yes.
And I was going to try not to interject.
No, I'm glad you did.
I was the awful case law person. One thing that my impression, as we were talking about beforehand, my impression with the district court judge in that case, he would not have given a who what sort of language you put in the consent relinquishment. Which that doesn't mean that other courts are going to do that if we don't get 744 in effect. But my takeaway from this case is I have to tell all birth and adopted parents that there will be no contact. Do you think that's overkill? But that certainly was my takeaway after this nasty, awful case.
I think that the trial court would have ruled exactly like you said, and said if you are promised a picture, then that's too much. I don't think the Supremes would have the same view. I think the cautionary language is the best we can do right now, but I don't want to be in a position where I'm forbidding people to have communication and contact, forbidding people to share pictures. I just have to make sure it's not a condition preceding to the relinquishment. That I have them understand, okay, you've said you want pictures quarterly. If that happens for 1 quarter and never again, you understand you have no recourse. There's nothing we can do about it. And it's a difficult issue, and I really hope that the legislature gets something passed. In the meantime, the cautionary language is the best that I can do, and make sure that there really are no agreements. There can be hopes and wishes about what might happen, but there can be no agreements on it. It's really a yucky place to be right now, because I think children and families and birth parents benefit from communication and contact. Most of it has gone to texting and shared private Facebook pages. Most of it's technology. It's no longer adoptive parents send me a pack of pictures and then I find birth mom and send them to her. We moved beyond that. And so how could I restrict it? How could I say, I'm sorry, you people cannot Facebook? So I don't really know the answer, but the language is the best I can come up with right now. And a lot of clarity and a lot of communication. Okay, so we've talked about revocation. We've talked about your role is in making sure that birth mom understands, birth dad understands if they're signing a relinquishment exactly what that means. I am very direct, because I don't ever want somebody to come back to me and say, Susan, you had me sign this relinquishment. I didn't really know what I was doing. You didn't tell me what I was doing. You didn't tell me the effects of it. I didn't know what I was doing. I was under the effects of alcohol, drugs, pain medication. I hadn't had any sleep. I say the same thing every time, so I could testify under oath. I said the exact same thing to this birth parent as I did every other birth parent. We go through line by line exactly what it means. No rights, nothing afterwards, not revocable. Have you had enough sleep? Have you taken any medication? When's the last time you had drugs or alcohol in your system? Are you taking pain medication? Has anybody promised you anything in exchange for your relinquishment? Have you been threatened in any way? Is there anybody who disagrees with your plan? How has that affected you? Have that conversation. You understand, if you sign this, you are transferring every bit of every parental right that you have to these people forever. Be that clear. It's the most important decision that they're going to make, probably in their lifetime, so they deserve the full facts and the full understanding of what they're doing. Okay. I just want to point out to you, page 85 in your handout, top 20 ways to screw up an adoption. We've talked about most of these, but read these. You got to take time, number one, you got to take time to get to know birth mom and understanding her situation. She needs to understand she's probably never met a lawyer before. She may have met a criminal lawyer before. She may have met a lawyer in connection with her parents' divorce, but she's probably never met an adoption lawyer. She doesn't understand what the role is that you have compared to the adoptive parents. She needs to understand you're not the puppet of the adoptive parents. You are her lawyer, and you need to explain what that means. Don't be afraid to ask hard or uncomfortable questions. You've got to get to the bottom of drug and alcohol exposure, birthfather issues, promises made to her, money, contact, pressure she's under. Has she worked with a prior attorney or an agency? And if so, why isn't she working with them any longer? Has she promised this baby to somebody else? Do you have somebody playing a scam where they promised a baby to couples in 3 different states and they're taking rent money from all of them? You've got to get to the bottom of that. Don't be a matchmaker. Don't have a birth mother come in and have you say, gosh, I've got these friends at church who really want to place for adoption, and so I'm going to match them up, and puts you in a horrible situation, and you can't really give independent legal advice to your client if you're rooting for this adoptive family to get this baby because they're friends of yours. Make sure you get mandatory or near mandatory counseling for birth mother. Agencies provide good counseling. There are birth parent support groups at Nebraska Children's Home. The agencies have in-house folks, and they're affordable, and you can use them. Don't allow an adoption plan to proceed without a completed home study for the adoptive parents. Don't wait until the last minute and then call the agency and try to strong-arm them into doing a quick and dirty home study as fast as they can. They need to do a good job on the home study. It's for the benefit of your birth parent client that a thorough home study be done. Now, having said that, there are times that the home study can't get done in time. Premature babies. So what do? Home study isn't done. Baby was born 6 weeks early. It's going to be in the hospital a couple of weeks, but it's still not time to get the home study done. Is it in the best interest of this child to go into cradle care or foster care pending completion of home study? Probably not. So what we've done and I've gone in and said, okay, here in writing, Judge, here is the situation. Baby was born early. Here's what's been done in the home study. Here's doing the home study. Here's a copy of their criminal background checks for the state criminals. They aren't child and adult abuse registry folks. Will you put in writing that the agency has the right to finish the adoption even with the child in the home, and that if it's done that way, you won't refuse to grant their adoption 6 months from now just on that basis? I've always gotten them to agree with that. So if you ever run into that situation, we've got a form letter that we use, and I can kind of walk you through how to go get that done. And typically, that letter signed by a judge has been sufficient for the agencies to feel comfortable finishing the adoption. Because, see, they have a licensing obligation to do these as pre-placement home studies. And so if the child's in the home, you don't want to get the agency in trouble for doing a post-placement home study. Dual representation of birth parents and adoptive parents, don't do it. It's never appropriate. If anyone needs an attorney, it's the bio mom. Number 7, make sure you have communication with the hospital before the delivery and during the hospital stay. You can't just send her to the hospital and send the adoptive parents and say, well, let me know when it's time to come up and do the relinquishment. So there's much more involved in that. You get her hospital plan. You tell the social worker what's going on. You send that in ahead of time so they can expect this birth mom to come in and they can handle it as a prospective adoption. They know who to contact. Send a release of information so they'll talk to you. I can't tell you, maybe 5, 10 times I've had a birth mother swear there are no drugs and alcohol involved, and I get a call from the social worker because she has my information and the release of information, and she said, well, there's methamphetamine on board. Okay, we got to deal with that then. Got to call these adoptive parents who are driving from Georgia and say, okay, I know you're on the way, pull over, let's have a conversation. This is not the adoption that you had planned on. Here's what the actual facts are. Baby is dependent on methamphetamine, he's going to have to withdraw. You know, you have to go through all of that information. And if the social worker doesn't have permission to call you, then you may not learn that until much later. Okay. You've got a plan to go there. You've got a plan. Birth mom doesn't know her rights. You've got to be there and help facilitate those relationships. All right, number 8, don't take a relinquishment before birth mom is truly ready. 48 hours is the minimum, but that doesn't mean you go in at 48 hours and 15 minutes and say, okay, it's time to sign. It's not time to sign. It's not a deadline. It's a minimum. She's had a C-section. She's still on oxycodone. you're not taking a relinquishment from her. She's not there. Make sure she's off pain medications other than maybe Tylenol, Motrin, maybe a slight amount of hydrocodone or something. But talk to the nurse. Make sure that they feel that she is ready to do a relinquishment. Make sure she does. Make sure her friend or her mom or her sister or birth father feels like she's of sound mind to make a decision. I really don't like taking relinquishments from birth moms who are sitting in a hospital bed after major abdominal surgery. Usually with a C-section, I try to wait 72 hours at a minimum. But when she's ready, and she's telling you that she's ready and you observe her to be ready, is the deadline, not 48 hours. Number 9, make sure you follow the Indian Child Welfare Act and the Interstate Compact Act. So Interstate Compact applies anytime a baby is crossing state lines for purposes of adoption. Indian Child Welfare Act applies whenever a child meets the definition of Indian child. Make sure you cooperate with hospital rules. Make sure that you partner with the hospital, follow their policy. My opinion is that you should not take a relinquishment as a notary. The notary should be a separate person who hears your advisement to the birth mother and understands and agrees with you that she understands what she's signing and is in a fit condition to sign. If you're the notary, then that's all on you. So I'm not even a notary. Years ago, I decided I'm not going to become a notary lest I be tempted to take a relinquishment as a notary. I sign off on it as the attorney. Separate notary, separate witness, you as the attorney. We'll talk about in a minute or two what to do with minors, taking relinquishments for minors. Make sure you get a signed non-consent form, medical history, social history. Make sure you read the statutes. Make sure you don't allow payment of improper reimbursable expenses. There's a handout in your materials about reimbursable expenses. That is on page, my apologies, 17. We don't have a statute in Nebraska telling us what could be reimbursed in connection with placement of a child for adoption. There's one case from 1980, and basically that case has turned into the but-for rule. What expenses or losses would birth mother not have had she not been pregnant or doing an adoption? So if they are related to the pregnancy, related to the adoption, then under Gray versus Maxwell, I believe they're reimbursable. So we're talking about counseling services, attorney's fees, maternity clothes, reimbursement for actual lost wages verified by a doctor's note, verified by a pay stub. The danger in reimbursing unallowed reimbursables is that it can be used as a basis for duress and coercion and undue adoption, and adoption, which is what happened in Gray versus Maxwell. Now, one caveat is sometimes when a baby crosses state lines from Nebraska to another state, birth mom will sign a waiver of Nebraska law and agree to proceed under the law in the receiving state. If the law in the receiving state is going to govern and they allow different expenses to be reimbursed than Nebraska does, then I think that will be fine because that's going to be finalized in that receiving state. So that's one caveat there. Yes?
Do you ever, as far as a notary goes, you wouldn't use someone from your firm?
I don't have a problem with that because that's still a witness who is going to be able to testify, yeah, I was there and I heard this said, and
All right.
so I do frequently use somebody from my office. And anymore, the hospitals are kind of uncomfortable providing notaries, so don't count on the fact that there'll be one in there. Some hospitals will cooperate, especially in smaller towns, but not necessarily. Okay. Any questions on what we've covered so far? That's an overview. We'll talk a little bit about forms and what's in a petition and doing the finalization when we talk about step-parent adoption. So if you're working on that, yes?
I'm just wondering if this is kind of going back a little bit from
Sure.
what you were talking about, but in terms of a bio parent and saying that you've never let them do their own thing without being represented, do you feel differently about that when we're talking about like an out-of-wedlock step-parent adoption, just sending, I guess my policy is kind of sending a relinquishment saying, you certainly can sign this, go see a lawyer or whatever, and if it comes back, I don't know I won't even allow to have it inside my office. They don't know.
Right.
It almost looks like kind of thing, but I've never felt like I should.
That's a great point. And
Encourage somebody to hire somebody for that.
Yeah, that's a great point. If I'm sending a relinquishment to the biological father in the step-parent adoption, or even the biological father in newborn adoption, it says in my notice letter, I don't represent you. I represent birth mom. I can answer general questions for you, but I can't advise you. I do advise you to see your own attorney. And in the relinquishment itself, it says, I've been advised if you have an attorney. I'm talking about going in and actually being there and taking a birth mom relinquishment from an unrepresented birth mom. Very good.
I got a question from the webinar.
Okay.
What if a mother insists upon relinquishing rights at the 48-hour mark and you want to wait another day?
If birth mom insists on giving her relinquishment at 48 hours and you think she'd be better off waiting another day, you can advise her, you can explain why, you can encourage, you can recommend, but in the end, if she insists on giving the relinquishment then I think you can take it unless she's impaired, because then her insistence is not knowing and voluntary. Any other questions off the web? Any questions here? All right, let's dig in on birth fathers. Okay. The statutory scheme is found in 43104 through 43104.25. You need to know if somebody's married. You don't treat a married dad the same as an unmarried dad. The 43104 scheme is for unmarried putative fathers and unmarried biological fathers. There are non-adjudicated putative fathers. So that's what I call Bobo the sperm guy. Okay, he's never been adjudicated. He's a possible, maybe he's one of 5 guys or 6. I don't know, what's our record, Tami? 6, 7? Anyway, you got to find them all. You may have information like, well, his name was Ace, and we had sex in the back seat of a car outside the Lucky Lady Lounge in Omaha. True story. Okay, so guess what? Or it might be this other guy. But I don't know his name. I know he had a tattoo on his arm, but I was drunk and I think I passed out during it. But so we got tattoo guy, we got Ace. We don't have any better, or it might be my boyfriend. Awkward. Boyfriend does not have the right to know that Ace and tattoo guy are other suspects. So you've got to be very careful when you're getting notice of boyfriend and getting consent from him or getting waiver of rights from him, that you not reveal the fact that there are another couple of suspects floating around. Got to get all the lay of the land, and you may have 3 different ways of notifying. Actual boyfriend may come in, get his notice papers from you, sign a receipt, be cooperative, do a relinquishment. Great, perfect. Ace and tattoo guy, you're going to get a John Doe publication. Because when I get stories like this, I always publish to John Doe, because I'm not sure that Ace and tattoo guy and boyfriend are the end of the story. So I'm going to, if that's the full extent of the story that I've gotten, then I'm going to publish John Doe, Ace, real name unknown, and tattoo guy. If you had sex with somebody in the backseat of the car outside the Lucky Lady Lounge and you go by the name of Ace, it was about this time, you should know that there's a pregnancy and an anticipated adoption. You follow the publication statute, you get notice out the best that you can. And you keep having conversations with birth mom. Are you sure? What if the child's life depended upon you finding Ace? Who would you ask? Who were you with? Who might have seen who you went and know who Ace really is? You can't just take the first answer. I can't tell you the number of times that I've heard, I don't know. I don't know who the dad is. Okay, that's almost never true. Every once in a while it's true, but it's almost never true. There's way more to the story, 90%. You've got to get that relationship there where she trusts you in dealing with it. So you might have non-adjudicated putative dads. You might have adjudicated, you might have a non-adjudicated biological dad. Maybe there was DNA. That almost never happens. but maybe he's never been adjudicated as the dad, but maybe they did DNA for some reason. So you have instead of a putative dad, you've got a non-adjudicated biological dad. The statute is the same. Or you've got an adjudicated dad who some court somewhere has said you're the dad. So if you're adjudicated, you're under 43-104.25. If you're not adjudicated and you're over the sperm guy or you're a DNA guy, the statute is the same. So what the statute summary is that you do this interview, you get this information, get the affidavit of identification, you check with the registry at HHS to see if there's ever been a document filed called notice of, not the notice of objection to adoption, but the notice of request for notification. Tami, what's the name of that thing?
I think that's what it is, request for notification.
Request for notification. Notice of request for notification. That is basically a sex registry. If guy has sex with somebody tonight, thinks that a child might be born of that union, and the child might be placed for adoption, he can actually file a notice of request for intended notification, saying, hey, if anybody ever files an adoption or in regard to this child, I want notice and here's my address. It's probably not used very often, but it was intended to strengthen the registry. So you need to check right away to see if anybody's ever filed anything with respect to this birth mom or any child born to her. Then you get your notice out to your birth father. Certified mail certified mail is what the statute says. Return receipt requested. The addressee, somebody else is allowed to sign it. Guess what we do? Do it again. A lot of the birth fathers are not in a situation where they are inclined to pick up their certified mail for a variety of reasons. So look at substantial compliance. What is the same as getting certified mail with a signature on the green card? Well, if they come to my office, I meet them, I check their ID, I hand in the documents, and they sign a receipt in front of a notary saying they got the documents. That's good. If I send a special process server out who serves them, that's good. If I send the sheriff out and serve them, that's good. Do not try to satisfy the notice requirements by giving birth mom documents to give to putative dad or putative birth dad, and then just have her say, well, I gave them to him. That's your worst option. Emailed back in a different language, which had to be translated, that yes, I got these documents, no, I don't have any problem with the adoption. Okay, that's the best we could do. Sometimes we've had to run publications in foreign countries where they don't allow publications of that kind of a sexual nature. They wouldn't allow us to publish something about Ace in the Lucky Lady Lounge. So we've had to modify the language in the notice. We've also then fully explained these circumstances in the affidavit of due diligence. That's your affidavit where you say, I met with this client, I got the information, I did due diligence, I checked Google and this people finder thing, and then all public record, and we couldn't find him. We tried, we talked to, I called 10 different phone numbers with this guy's name, couldn't find him, so we published. Tell the judge everything that you did to try to get actual notice to this birth father before you publish. If he's around, find him. There is enough technology around that you can find people, and Laurie Montag will tell you how to do that. But I would never publish to somebody I knew was running around Lincoln. They're findable. Okay, so you get notice on them. Sheriff certified mail, special process server, a receipt. If you use a receipt, you'll see the sample receipt that we use in your materials. Make sure you check their ID. When you've done your birth mother interview, you've asked if there's any special things about their appearance. You know, what's their race? What's their height? What's their weight? Do they have any special markings, facial hair? Make sure the guy who comes to pick up the documents matches that identification, and then also get a copy of the driver's license or some form of ID. Okay, so then the birth parent birth father has any time during the pregnancy and up to as late as 5 business days after the birth to file an objection with Health and Human Services. You want to do everything that you possibly can to get him notified, either publication or certified mail or sheriff or special process server, before the birth. Don't dink around and not get it done. Babies like to be born whenever they feel like it. So we try really hard not to wait any later than the 7th month to be doing that. There's no strategical advantage about waiting until the 9th month. All you're doing is risking having the period of time that they can object extended because you didn't get your publication done before birth. Because it is the later of the two, 5 business days after notice or after the birth, whichever is later. So if you get your notice done during the pregnancy, then you've got 5 business days after the birth for them to file an objection. It's timely filed if there is a postmark on that filing within the 5 business days. So you actually wait, if you've got a birth father who's on the fence and you're waiting to see if he's going to file an objection and you're hanging loose and you're not having your birth mom sign relinquishments, don't just wait 5 business days. You've got to wait another couple to check the mail with HHS to make sure it wasn't postmarked before that. Okay, so if the claim is filed, that's not the end of the story. If a claim is filed, and I'm on page 8 of the outline, by the way. If a claim is filed, that doesn't mean the birth father automatically obtains custody of the child or even the right to custody of the child. The filing triggers his right or birth mother's right or an agency's right to file a petition in the county court of the county where the child was born for an adjudication of the objection to adoption. That's in 43-104.05. And I put all of the adoption statutes in your manual for you. That way, there's no reason not to read them, and they are all the up-to-date versions because there have been a number of revisions. So they're in your manual. If the child was born out of state, then the customary rules for venue would apply, in my opinion. So the statute says file in the county where the child was born. If that's not possible, file in the county that it would have appropriate venue. An adjudication of the claim is essentially a proceeding to see if birth father can block the adoption. Can this adoption go forward without his consent? He has 30 days to file that petition in the county court where the child was born or the county court with appropriate venue in the case of a child born out of state. The standard, the crux of the adoption statutes on birth father's rights to object and block an adoption are found in 43-104.22. So he would have 30 days to then proceed and have a determination of whether his consent is necessary or not under 43-104.22. If birth mom says, hey, I'm not even sure he's the dad, he's ace, but I don't know. Then the first thing the court's going to do is order DNA testing. If he turns out to be the biological father, then you proceed to the 43-104.22 criteria. If he's not the dad, if he's not the biological father, 43-104.22 sub 11 says his consent is not necessary if he's not, in fact, the biological father. So make sure you have a clear understanding from your client as to whether or not there's some chance that he's not the biological father. I've had numerous occasions where birth mom said, I'm absolutely sure he's the only one. DNA got done for some reason. It's not him. Then one even, she said, oh, okay, then it has to be this guy. We did DNA. It's not him. Third time was a charm. So you've got to stay after it until you get it solved. Keep in mind that the underlying goals are substantial compliance, due diligence. It doesn't mean literal compliance in circumstances where it's not literally possible. Watch out if any of the birth fathers are in active military duty. There's special rules under the Soldiers and Sailors Act that you'll want to be mindful of. Judges will look at your due diligence in finding these folks. Do not be cute or clever or try to take a shortcut. You'll get burned on it. And you don't want to place your professional credibility and your professionalism at issue just to try to avoid getting actual notice to a birth father the birth mom doesn't want to know about the adoption. To bolster the strength of our notice statute, it's been held constitutional And the statute tells you specifically what needs to be in your notice letter to the birth father. I believe some additional information should be in there to bolster the constitutionality of the birth father statute. If you turn to page, let's look at a copy of the relinquishment, or a copy of the notice. If you look at page 154, that is a sample letter of what you would send to the birth father by certified mail or sheriff delivery, special process server, by receipt. At the bottom of page 154, it starts with, you may file a notice of objection to adoption and intent to obtain custody at any time during the pregnancy and up to as late as 5 business days after the child's actual date of birth or receipt of this notice, whichever is later. If you fail to do so, your right to object to the adoption will be extinguished. If you wish to be advised of the actual date of birth of the child, please contact me to provide me information about where you wish to be contacted to receive that information. At that point, it'd be really hard for him to say, well, I didn't get the 5-day notice filed in time because I didn't know the birth of the child. You told me it was expected to be this date, well, it was 5 days earlier. I also told you you could contact me, and I would contact you to tell you the actual date if you needed to know that. And the statute doesn't require that information, but I think the standard of care, the gold standard right now is to put that information in there, as well as let him know he has 5, anytime during the pregnancy as late as 5 business days after the birth, to file the objection. I just think there's a lot of pressure on that 5-day number. It's probably shorter than most states, but my position is you have 9 months and 5 days to file an objection, not just 5 days. So I advise that additional language. All right, let's talk a little bit about adjudicated dads, and unless you've got questions on, yes, very good.
Hypothetically, you've got, birth mom and all this stuff, that the mother indicates, well, this is probably different than juvenile court. What impact is for a birth father who goes in and gets paternity decree after the birth of the child, and what impact do these notices have?
Okay, so the child is born and there's been a paternity proceeding, and the adoption is not on the table until later. The birth father's already been adjudicated. Is that what you're saying?
For a punitive person, was adjudicated. So you've got a father there. I'm just asking what the impact of these notices are on a father that learns subsequent to the birth, maybe as much as a year later, that he was even named as a potential father. Goes in, determines he is the father, then he files for his paternity within that, statutory period of time. Do these notices have any impact on that order of paternity?
No.
Then blocking an adoption.
If he's been adjudicated,
Yeah.
then, perfect segue, Mary Claire, we were just going to go to 43104.25 on page 81. Your adjudicated dads, there was a case, In re Jaden, that's in your materials at page 11, from 2006, that said that the notice documents and notice procedure we've been talking about does not apply to an adjudicated dad. So 43104.25 was enacted, and that's page 81. The statute is found at page 81, rather. And you'll see that the process with regard to an adjudicated dad is largely the same, at least to begin with. Any person who's been adjudicated by a Nebraska court of competent jurisdiction, and I would say if they've been adjudicated by a court outside the jurisdiction, you're going to want to go to the court that has custody of the child in Nebraska or use basic venue provisions. If the child has been adjudicated, then that guy is not considered to be a putative guy under 43104.02 through 0.05. Having said that, you're still going to send him notice of the planned adoption, of his identification as a putative father or a biological father. But why are you going to do that? Because you're going to send him consents or denial of paternity or a waiver of rights, and he may decide, oh, I'm good with the adoption, and sign a consent. In which case, that's the best interest of the child. Get a social history, medical history, consent. So you're going to still let him know what's going on. but you don't count 5 business days after his receipt of notice and then have his rights be considered over because it doesn't apply to him as an adjudicated dad. But you're still going to send the same notice. If he doesn't sign a consent or relinquishment, or he doesn't respond to the letter, which is most frequent, then you're going to file a motion in the court with jurisdiction over the custody of that child. You have to seek that consent you need. So you're going to combine a motion, hey judge, give us consent of the court and make a determination under 43104.22 as to whether this adjudicated dad's consent is necessary. Many, many, many times a birth father gets adjudicated to be the dad because birth mom got Medicaid or WIC or whatever, and the state pursued a paternity action against dad. Dad didn't pursue a paternity action seeking custody of the child, but the state did. And there's findings, maybe there's findings of visitation or custody or child support. In the broad definition of adjudication, there is no definition in the statute, but in the broad definition of adjudication, I would submit that if there's an order regarding child custody and he's identified as the dad and the person to pay child custody or child support, then that's an adjudication. I'd err on that side. So you're going to the court that has jurisdiction over the child, filing a motion for the court's consent, and filing a motion for that court, usually a district court, sometimes a guardianship court, county court, asking that court to adjudicate whether this guy's consent is necessary under the 43104.22 criteria. This is an exception to the statute that gives exclusive jurisdiction over adoptions to county courts. So some district courts, especially in counties where they don't have a lot of adoptions, the district court's going to say, wait, this is an adoption thing. We don't have jurisdiction over that. The legislature has carved out that if the district court is the court with jurisdiction, they've got to give their consent, and they are the ones to determine whether the birth father's consent is necessary under 43104.22. So there might be a myriad of reasons under 43104.22 that the adjudicated dad's consent is not necessary. One of the reasons could be that he's notified of the hearing in front of the district court over whether this adoption is going to proceed or not, and he doesn't show up. So you're going to have to serve him like you would serve him notice of the petition in a civil proceeding. If he doesn't show up, fine. Or he could show up and say, I'm good with the adoption. I didn't know about it. Where do I sign? Or he may show up and contest it, and then you have a contest over whether or not his consent is necessary or not under those criteria. So that answers that, I think, very clear. Yes, Jeanette?
What do you do for out-of-state adjudications that happen in Iowa?
I hate them. My position is if they were adjudicated in another state and now the child never resides in Nebraska, I would, A, probably try to get that jurisdiction transferred to the Nebraska court with appropriate venue, get a judgment transferred. If I can't do that for whatever reason, then you would probably go to the county court in the county where the adoptions can be finalized and file a petition there and explain the problem with getting determination from that out-of-state court. But if you could transfer the judgment, transfer the proceeding to Nebraska, that would be my first course of action.
You've never actually gone so far as to do something in the Iowa court with different counsel if you're not licensed?
I haven't had to. Lots of times you can get consent from those folks. So that solves it. Because you don't, under 43104, you don't need a consent of the Iowa court to the adoption. 43104 says a Nebraska court has jurisdiction over the child. If you do an adoption and a court in Iowa still has jurisdiction, I usually send them a copy of the decree of adoption so they at least know what the heck's going on. But it's a very complicated area. Other questions? All right, let's go over some of the case law that has happened as it relates to adoption and in particular birth fathers. Let's turn to page 10, Brakhage versus Rausch. I won't read you all the facts of that, but the Brakhage case taught us that if a birth mom had not relinquished at the time, then county court might not have jurisdiction. So the legislature amended 43104.05 and 4311411 to clarify the jurisdictional relationships between adoption proceedings and paternity proceedings, and to clarify when a paternity action is precluded by pending adoption proceedings. So that changed 43104.05. So you should carefully read 43104.05, especially if you have a birth father who's come forward to contest the adoption. You don't want to take a relinquishment from your birth mom and have her sign her rights away irrevocably while you still have an unknown birth father situation. But she's got to sign within 60 days, because if she never proceeds forward, then if she decides not to do the adoption, then it gets transferred to the appropriate district court for paternity proceedings. So read that section carefully. In re-adoption of Jaden on page 11, we talked about that. That's adjudicated dads. The court held that the notice procedure 43104.227.02.05 doesn't apply to an adjudicated dad. So then the legislature created 43104.25, which we just got done talking about in terms of adjudicated dads. Okay, here's the most difficult issue in adoption that I want to talk about. In re-adoption of Corbin, page 12. The step-parent and biological mother petitioned for the stepfather to adopt. The bio dad was never adjudicated to be the legal father. The county court granted the adoption because the birth father failed to timely file his objection within 5 business days after notice with Health and Human Services. The Supreme Court reversed and said that the registry, the Friday notice, 30-day filing in county court, that whole process cannot be used to tie off the rights of a birth father who had a, quote, familial relationship with the child. Absent from that opinion is any definition of what familial relationship means. I have thought about this issue about 100 times and tried to figure out how do we statutorily solve this situation. And without blowing up the entire adoption statutes in Nebraska, I don't know how to do it. So we have to look at what's the practical effect. Well, first of all, let's back up. When you're doing your interview with this birth mom or with this adopted family or whomever, you've got to figure out if there's a familial relationship. And you got to figure out, did you live with them? Did you pay child support? Did y'all live with his mom? What was going on? If it smells like it might be a familial relationship, you've got to know that you're dealing with that. If there's no familial relationship, I put that in birth mother's affidavit of identification. No birth father has ever been adjudicated to be the dad, and no birth father has ever been in a familial relationship with this child. I put that in mom's affidavit of identification. I put that in the petition when we finalize. Because I want those judges to know we're not talking about In re Jaden. We're not talking about 43104.25. We're not talking about In re Corbin. There's no familial relationship, so you can rely on the statute. Okay, but let's say you do your interview with birth mom. She wants to do an adoptive placement of her 2-year-old. She's tried to parent. It's not been successful. She's got child protective services breathing down her neck. She knows she's not doing a good job of it. She's found this family at church. She's in love with them. They've got their home study. They're going to do an adoption. You've got to figure out what happened in the 2 years there. Where has birth father been? Okay, so she says, well, the first year we all lived together. And yeah, he kind of paid some child support. He helped out a little bit. He was in and out of rehab. He was spent some time in jail, but he was kind of there. And he used to beat me up. But so I broke up with him after the child was 1. Is that a familial relationship? I don't know. Probably could be. The Corbin case made it clear that the quality of the familial relationship is not the key. So he could have been a terrible dad, terrible boyfriend. But if he had a familial relationship with that child, he may have extra protection. So what do we do? I still would send him the notice. I would still check the registry. And I'd put in the letter, my client tells me that she does not believe you ever had a familial relationship with the child. If you feel differently, please contact me. That's my first way of trying to flesh that out. If I feel like there's a strong likelihood that he could argue familial relationship, maybe he doesn't respond to my letter, probably doesn't respond to my letter. I check the registry. I still plead all that in my adoption petition down the road. I tell this adopted couple, this is a legal risk placement because I don't have a relinquishment from a dad who might be a familial relationship dad. And so then when I get to final, I put that in writing to people. We don't have a consent, might have a familial relationship. We've notified him, he didn't respond. I'm not sure we can hold him to the registry. At the time they do the finalization, then my recommendation would be to notify him of the filing of that adoption petition, put in there that you don't believe that he's established a familial relationship or that anybody's come forward having a familial relationship, serve him notice of that adoption petition and the hearing date, and if he doesn't show up then, I think you're done. It's not a great solution, but it's the only one that I can come up with. So if you're doing step-parent adoptions and you think, okay, I don't feel comfortable doing newborn adoptions, they're complex, I don't want to deal with ICWA, and I want to deal with interstate compact, but I'm going to do these step-parent adoptions, you're actually more likely to run into the familial relationship problem than anybody who does the newborn placements. So if anybody can come up with a better solution on familial relationships, tell me, please, because I would love to know a more streamlined way, less legal risk way to deal with it, but right now I can't come up with one. So be very careful there. The best way to deal with it, getting consent from him. Then you're done. Okay, so Jeremiah versus Dakota, page 13. This was an unfortunate case where birth mother specifically misled birth father about the birth of the child. She spoke to him a couple of days after the delivery and didn't tell him that the child had been born. He missed his 5 business day deadline. He was notified of the expected date of birth, but I believe there was some difference between the expected date and the actual date, and she withheld that information from him. And so the court said that he stopped from relying on the statute, having participated in efforts to frustrate his ability by withholding that information from him. At that time, the statute said you had to file your objection within 5 business days after the birth. That was a result of a 2007 change, which was intended to clarify that statute, 43-104.02, but probably didn't clarify it as well. So subsequently, the statute was revised in 2014 to make it clear that he could file his objection anytime during the pregnancy and up to as late as 5 business days after the birth. But this case, Jeremiah case, is the reason that I suggest that additional language in the notice letter to the birth father, so that he knows exactly how he can calculate the 5 business days that he has to respond. He knows he has 5 business days, and he knows he can contact you to find out the birth date, and I, of course, will tell him so that I'm not frustrating his ability to act under the statute. We'll skip Monty and Teresa because we already talked about them in connection with openness. Last caution, quickly, is Carlos versus Lindsay 2012 case. Both birth parents were 15 years of age. The statutes say nothing about whether a minor can relinquish. My position has always been, up until this case, that nobody else other than the 15-year-old birth mom has the right to relinquish. There's nobody else with custody of that child, so therefore, even though a 15-year-old can't rent an apartment, can't sign a lease, can't sign a purchase order, can't sign a contract as a minor, there's nobody else to relinquish other than her, so from whom would I get a relinquishment? Carlos versus Lindsay says that a birth father who's a minor doesn't have capacity to file a lawsuit to have his claim of objection to the adoption adjudicated, and a 15-year-old can't be sued in response to it. The Supreme's made a little bit of a passing comment about, hey, some states have statutes on this. Hint, hint. We don't have one. So I'd like to get one. Their hint was basically some states say age of minority does not preclude the birth parent from the ability to sign a relinquishment. So I'm hoping we can get something clarified in the law. In the meantime, if you're representing a birth father who is filing a lawsuit to adjudicate a claim objecting to the adoption, he or she should be represented by guardian or next friend. You have to get somebody appointed to help that person file. If you're taking a relinquishment from a 15-year-old, and I've only done it once, I've only taken a relinquishment from somebody under 19 once since this case came out. And I think there's an exception to the age of minority that 18-year-olds can sign contracts. So if I took an 18-year-old, I would rely on that statute. I took, I guess she was 16 by the time we did the relinquishment. I had her mother sign off on, as legal guardian, natural guardian, next friend, I had every possible descriptor under her name, and she signed off on the relinquishment with birth mom. I think that's good enough, but I can't swear to it. Yes?
What if birth mom doesn't want, not birth mom, birth grandma doesn't want? And a lot of times there's undue pressure from that, and I think that's, so I just had one and it fell apart. That she ended up deciding to keep the baby.
Okay.
But she was.
What if birth grandma is not on board with the adoption and the birth mom's a minor?
Really, you're basically holding that kid, well, kid, she's 15, but holding her hostage to her parents' consent.
I think I'd go around mom. I would probably go to court to get a temporary guardian appointed for birth mom for the purposes of facilitating her relinquishment, because I wouldn't let birth grandma bully birth mom into parenting.
Right.
And, birth mom's got to understand we're going to create World War III if you do this. But that's what I would do in that situation.
Well, in this case, the birth grandma already kicked birth mom.
Yeah. So an even better reason to get a temporary guardian established.
But I did end up having to go down that rabbit hole because she decided on her own to keep the baby. But I just circled that in my head a million times. Like, we can't put a position where grandparents have sometimes say.
Right. Grandparents do not have any more right to that particular child than you or I do. But they are a source of pressure. I had one fall apart last year where birth mom was adamant. Her mom was already raising her other 3 kids, and grandma said, I'm not raising 4. And grandma changed her mind at the hospital, and the whole thing fell apart. So they do play a big role. That's why I always ask, who in your life is in support of your adoption plan? Who in your life is not in support of that? How do you feel about that person's involvement? Just trying to get to the bottom of that ahead of time so I can understand the dynamics. Sometimes I've had to run interference where birth mom has said, do not let my mom in this hospital room. I'm 24 years old. She's manipulative. She's this, she's that, she's that. Do not let her in here. She has the right to say that. Birth moms have a right to register at the hospital under what we call silent registry, where if you call the hospital, if I call the hospital and say, my client Betty is up in labor and delivery, they'll say, no, she's not. She's under silent registry. Yeah, she is. Just tell me what room she is. Nope, she's not here. I mean, I have had difficulty breaking through the barrier to find my own client under silent registry. So they have a right to register in a way that their presence would not be disclosed to somebody calling in. So you've got to get to the bottom of those dynamics before you can help them decide whether that's a good decision or not. All right, I think our time is up. Any questions on this area? All right, our next presenter is Laurie Montag. Laurie's going to present on how-tos for locating birth fathers. Laurie is a paralegal at Klein Williams, Wright Johnson Oldfather, is a valued litigation paralegal for myself and others. She has over 15 years of experience providing support in all areas of litigation, and she is the wizard at finding people. Welcome, Laurie.
Good afternoon.
It's not on. Now it's on.
Okay, that was easy. Okay, thank you. Well, we'll make this as brief as possible because I have a feeling that most of you have tried to do this before, and we'll just cover a few high points. I enjoy doing internet research, so this is something that I kind of dig into. I find it to be a challenge, and I also find that sometimes it's like putting the pieces of a puzzle together. So you may have to go to several different resources in order to locate someone, but it's just amazing to me how much is on the internet. And how many people take the opportunity to post, and Facebook, and LinkedIn, and all kinds of resources that are fairly accessible to all of us. First of all, as Susan mentioned, get as much information as you can. Use all of the information you get from the birth mother, because it can all be clues to you as to where to locate these people, or this birth father. if you can get Social Security numbers, that's really wonderful, but you may or may not be able to have that information. The first thing I would do, and then of course spellings are I mean, if you don't have an accurate spelling, that can really impede your search. But then that's all part of putting the puzzle together also. The first thing I would do, if I have access to Lexis or Westlaw public records, is to utilize that if you have the funds to do it. They have access to credit headers and utility information, and we've had great success using Westlaw People Map is what we use at Klein Williams. So that would be, if available, that would be my first stop. If not, it's possible to find people through just a general internet search. I use Google. Google the name. You can use the advanced search function if you are familiar with that. And I think there's possibly even a fuzzy search resource on at Google Advanced, so that if you're not sure of your spelling, you can get a sounds like result. Common surnames are a problem because there's lots of Smiths out there. So I would encase that search in quotes in my Google search and just to kind of narrow that down. However, in general, I like to cast my net broadly to see what I can find the first time, especially if you've got a last name that's not real common in the area. Also, you know, if you have a handwritten information from the birth mother, her handwriting may not be particularly legible, so sometimes that can be an impedance also, but it is possible to overcome. Secondly then, if my Google search, hopefully I've gotten some results from that, and then you can use the directories. White pages, but I really like ZavaSearch. Have any of you used ZavaSearch? It gives you a lot of good information, and it's free. And of course, you can chase down and pay for information if you find that you want to pursue that a certain path or a result. But you don't have to. Generally, I've been able to get good free information from ZavaSearch. Facebook is also, of course, an option. You don't have to be a Facebook member in order to search Facebook, but you do have to look for the little link down at the bottom of the Facebook homepage, people. And once you find that people link, and you can actually do a search. Unless you are logged into Facebook, you may get a limited amount of result. However, there is also an access route on Facebook where you can pull up an actual list of people that are on Facebook. And it's usually alphabetized by their first name, because doesn't everybody go by their first name these days online? But you can chase that down too, and I believe that's a comprehensive list of all the people that are on Facebook. That will take you a little bit of time to chase that down, because you have to keep digging into the subdirectories. But you might be able to get good results that way. You will only be able to view what is public, and you won't be able to view whatever is posted only to friends or to family. But oftentimes you can get good information from Facebook. LinkedIn is another option. It's possible that, but do be aware, if you search LinkedIn, that if you are logged into LinkedIn when you do it, the individual whose record you're looking at will know that you looked at it. So I usually log out of LinkedIn before I do any searches. That way I'm not getting quite as much information, but I'm getting the information that I need for this purpose. If you believe the birth father may be a homeowner, you can always search the property, the county property tax records. I find that we have such wonderful records online in Nebraska that it's fairly easy to do that. If you have to search for another, in another state, this National Association of County website that I've given you at the bottom of the page here is a good resource to locate what county you're looking at and whether or not they actually have their property taxes online, if they have property tax. Well, of course, we've got wonderful online court access here in Nebraska. The justice side, I always plumb that anytime I'm looking for someone because traffic tickets, recent traffic tickets, will always list an address. And of course, if there's a criminal record, that information will be on there also. So I always check that, and I've also listed here a website, I believe, where you can find that information for other states if they have online access to their criminal records or their general civil records. So that's a good resource. Once you've done your justice research, you may find that you are looking for someone who may in fact be in prison or in jail. And the state also has wonderful inmate locators, and most states have inmate locators. Also in Nebraska, if you're looking for someone who is in jail versus prison, there is BindLink. I haven't had an opportunity to use this. I came across it when I was doing a little research for this purpose, but that's actually a victim's website. But it will also tell you. They are linked into the county sheriffs, and so you may be able to find if someone is in jail in another county. The Federal Bureau of Prisons also has an inmate locator, although, well, who knows? You may find your individual that way. After 9/11. We've just become more closed up as far as the number of resources for finding someone such as military records. I have not had to use that personally, so I don't really have any personal experience with it, but I did locate this particular locating service that had some good tips on it. So if you have to go that direction, that may be something for you to look at. It is also possible, and I have not had to do this personally, but I did call the Election Commission here in Lancaster County, and they did confirm to me that you can call the Election Commission, and if the individual is registered to vote, and you have an address or you have a possible area of location, they will help you online or on the phone. So that is another possibility for you to locate someone. Postal Service, if they have filed a change of address, you may be able to gain access to a change of address through that. And if you have the information about an employer or a former employer, they may be able to tell you where they sent a W-2, or you may be able to find some coworkers. And then again, if you can find that individual on Facebook, that may give you some information as to people to contact or places to try. Do any of the rest of you have some resources you'd like to share with everyone else here that I haven't covered? Any gold mines out there? Well, it's an interesting challenge to try to locate people, but yeah, you will find that you will generally be able to get a good idea of where to locate someone. That's about all I have, so thank you. If there's any questions. Okay, thank you.
Thank you, Laurie. One practice pointer that occurred to me as Laurie was talking is if you are doing a publication to a birthfather, you need to send notice also to his last known address. And so even though you can't find him, this may be a resource to find at least the last best known address, and you're going to want to cover that in your affidavit of due diligence. And also remember, you don't have to do these things sequentially. You can try to get him to pick up certified mail. He doesn't pick it up. You can send the sheriff out looking for him. Sheriff can't find him. You can run a pub at the same time so that you're getting that publication completed at the time that you've completed your due diligence. If you get him served, great. You published for nothing, but at least you got it done. Our next presenter is Tami Rager. Tami is with Klein Williams Wright Johnson and Oldfather. She's a paralegal in the adoption and probate practice area. She's been my teammate in the adoption area for more than 20 years. She's also an adoptive parent, and she has more than 20 years experience helping families in the continuum of life from birth and adoption to estate planning and probate. And Tami's going to tell you how to prepare and file an international adoption finalization.
Okay, excuse me. As Susan said, I've been a paralegal for her for 22 years now, and during that time we've had the opportunity to finalize adoptions from all over the world. You'll find that each country is a little bit different in what they require, so you'll have to address that separately in each petition, but the Nebraska requirements are, of course, the same. Nebraska requires that you include the original certified foreign documents along with an English translation. If there's not an English translation provided, we would typically go to UNL. They do provide English translation, or sometimes the country will have written the documents in English in the first place. The foreign documents need to state in some manner has consented to the adoption, or that her parental rights were terminated, or that the child has been abandoned. They need to state that the court or government agency has approved or established adoptive relationship. Although the statute references saying that immigration of the child is allowed, that's almost never in the documents. I don't recall ever finding that in the foreign documents, and it's never been an issue. If a guardianship was established with an agency or parent, then you do need also to obtain written consent from the agency. The homestead requirements of adoption, let me get it there, sorry. Anyway, the homesteading requirements of adoption do still apply the same as they do in a domestic adoption. The homesteading needs to be current within 1 year finalization, and you need to include any updates or post-placement reports that there may be. You will find that some countries require additional post-placements for 1, 2, sometimes 3 years after the placement occurs. Your clients do not need to wait for that time period to end before finalizing the adoption. The usual 6-month rule does still apply. Once your client has provided you with the foreign documents, then you obviously need to start your petition. If you have the foreign birth certificate, you will want to include that. That's not always included. Sometimes if it is included, it's still in the birth mother's name, or sometimes the foreign country will have provided an adopted birth certificate, but still in that other language. Either way, if you have it, great. If you don't, you're still fine. To review the documents and to try to summarize the information in a way to show that the child was placed for adoption and that the court or government established some sort of an adoptive relationship, or in the case of some countries, a guardianship. Readoption is not recognized in Nebraska. Do not use this term in your petition. We'll talk about that a little bit more in a few minutes. Typically don't want to use the term finalized because then that does raise again acknowledged or confirmed the adoption. That asked the Nebraska court to return the original documents to you as keepsakes for your file. Almost every adoptive parent wants to have the original staff, so we've just made it a standard pleading that we include in all of our foreign adoptions, and we have never yet had any county court in Nebraska refuse that request. Guardianship versus finalized. South Korea and Canada established guardianship. In those cases, appoint a guardian in Korea, and then that guardian consents to Holt or whatever your agency is, being then having the power to consent, and then Holt will then provide the consent to the child coming back home. Readoption, as I mentioned before, is not recognized in Nebraska. You do not want to use this term in your pleadings. This can trip you up with the court or the judge. Years ago, we had a client or clients who tried to finalize their own adoption on their own. They had pleadings with the court throughout their petition and all of their documents. They continually used the term readoption, and the judge then refused to finalize their adoption because, in his view, there was no statutory readoption that exists in Nebraska. They then came to us. We went in, Susan went into court and tried to clean up the whole mess. Susan did get finalized, but it can create a problem. Your clients will, however, use this term probably quite a bit because they've picked it up from their agency. That can lead to them the only way to get a U.S. birth certificate is by finalizing locally in your county in Nebraska. If the adoptive parents don't believe that they need to do this, quite often, 5, 6, 7 years later, when they're trying to get the child into school or get a passport or something like that, all of a sudden they need a U.S. birth certificate. The only one that they may have, or the only birth certificate that they may have, is the one from the foreign country, which may still be in the birth mother's name, or it may not be in English. So then they come to you 5, 6, 7 years later, and you now have to try to finalize the adoption form. It can be done. We have done it a number of times. It is a little bit more difficult because you do have to go back and find all of the original foreign documents. They have to find their copy of the home study, the post-placement reports. Depending on the people, that can be a problem sometimes if they're not very organized. It also can be a problem with the courts, depending on the court. We've had Douglas County in the past require that the background checks be current at the time of finalization. So these adoptive parents who've had their child here at home now for 6, 7 years now have to go back and get their background checks done because Douglas County otherwise would not finalize the adoption. You will sometimes, as I mentioned before about the decree, you will sometimes run into some unusual circumstances. We have had a situation with a child from Africa who was given the wrong age, the wrong date of birth. Adoptive parents brought her home. Her doctor and dentist, based on physical characteristics, determined that she was 2 years older than what her birth date said. Because it was such a large difference, the adoptive parents asked us to try to get that corrected in our petition for adoption. So we did explain the situation in our petition. We attached evidence from the doctor and the dentist, gave the new birth date that the adoptive parents wanted her to have, and we were able to get that done, no problem. Another unusual situation that you may run across from Africa, the tribes often do not recognize any importance or place any importance on a birth date. So we have run into situations where, these children, no birth date is given, they don't tell the child the birth date, they don't write it down, nobody knows what it is. Years later, when they are now in an adoption process for whatever reason, the court or government agency does need, of course, to have a date of birth. So, for example, we have a situation where we have a sibling strip of 4 siblings who all have the date of birth of January 1st, which was way too odd to be actual. You don't need to include something like that in your petition, but you should be ready to explain that to the judge if the judge has any questions, because obviously, it's an unusual enough circumstance that it most likely is not correct. I have attached several examples of petitions in the back of my section. The first one, South Korea, establishes a guardianship. The others were all finalized in that country: China, Haiti, Russia, Guatemala, Ethiopia. The Guatemalan petition that I have provided is one, for an example, with a single parent. And then the Ethiopian petition is the one wherein we had to change the child's name. Does anybody have any questions? All right.
Thank you, Tami. We're going to take a 15-minute break now. Come back in. I wanted to let you know, if you are interested in having any of the forms that are in the manual, you can email me or Tami Rager, and we can send those to you in PDF, or if you prefer them in Word, we could. Our next presenter is going to present on the interstate adoption and ICPC compliance. Our next presenter is Deanna Brakhage of the Nebraska Department of Health and Human Services. She's an ICPC specialist, meaning interstate compact on the placement of children, and she's worked in that capacity for several years. So if there's a packet of documents for a child to leave the state of Nebraska and go to another state, or leave another state and come into the state of Nebraska, Deanna and her staff are the ones who give approval for people to be able to cross state lines with an infant for purposes, or a child for purposes of adoption. That arises both in infant adoption, older child adoption, statewide adoption, anytime a child crosses state lines for purposes of adoption. So welcome, Deanna.
First off, I would like to introduce Laurie, where she is also an interstate compact program specialist at the department. So about the interstate compact. The very last document is a check sheet. That is everything that we need in the case. And so it's just a running tab. It's just a running list of what we need in a packet. You can include that with your packet, or when we get the packet, we fill that sheet out. And then if there's documents missing, we will email you back and let you know what one's missing. Okay. So what I'm going to go through is the actual documents that have to be in the packet. The ICPC 100A, it's a standardized form. You can find that on the DHHS website. It's on the homepage under adoption, and it's basically called Interstate Compact, the 100A form. This is actually the form that we send to the other state, where the other state signs off, says, yes, this child can come to our state. The birth parents, the mother has to sign that. It's not you as the attorney, it is the birth mother, and it has to be signed prior to the relinquishment. Cover letter, that will be a cover letter addressed to the Interstate Compact, and it'll be from you, basically giving us an overview of what the situation is. It will talk about the parent, what the situation is. Was it the child was born out of wedlock? Was the mother married? Is there Indian child welfare issues? Has there been court issues? Anything that kind of gives us a heads up of what we are going to be looking for. The consent or relinquishment, that is pretty self-explanatory. We do want it. Hopefully, it would be nice if we have it on both parents. Obviously, we need it on the mother. And then if the father, he has not signed a consent or relinquishment, then we need the due diligence, we need the publication, we need to know everything that you have done to locate and notify that father. We will, this is probably one of the things in the Interstate Compact that we really focus on is the fathers. We want to make sure those fathers have been identified, or at least the attorneys are looking for those fathers and what is the plan. Several states have different requirements, and when we get a child into Nebraska from another state and they have different requirements on birth fathers, we will also ask for their statutes regarding that so it matches up with the packet that they sent to us. Certification. This may be new to some of you. This is a new requirement for ICPC. It is a letter from you as a licensed attorney to identify that everything that you have done through the relinquishment process is valid and is according to Nebraska statute. So it's just you claiming that you have done everything appropriately. Verification of compliance with the Indian Child Welfare Act. That would be signed by both the birth mother and the father. He has signed a relinquishment also. This is to identify if there's any possible ICWA and any notifications that need to occur. Legal risk, that is signed by the adoptive parent. Usually it's a generic legal risk. However, I know in a few situations recently where there has been significant meth use or schizophrenia, significant mental health, I may ask the attorney I would like the legal risk to be a little bit more detailed, because there's nothing in the packet that shows me that these adoptive parents were even told that there was schizophrenia in the history, or there was anything that the adoptive parents may need to know. So if we find through our information in the packet, we may come back and just ask for a little bit more detail on the legal risk. Statement of authority. This is a statement of the sending agency for the authority to placing the child. That is more for the agencies that have the authority to place a child and have custody of the child. Current case history of the child. If it's an infant, we need the hospital records or the discharge summary from the hospital. We will not send any packets on until that's been sent to us. And so that can delay the process if you can't get the records from the hospital, but we will not send that packet on to the other state until we have all of those records and discharge summaries from the hospital. For the older child, this is probably where it's been more challenging for attorneys, because we will ask for medical histories dating back to if the child was in the custody of the department, how long medical history all the way back. And so that has been more challenging. We will be willing to work with you if we can help obtain some of those records. If the foster home is licensed, we want a copy of that license. Adoptive home study, we will need the original adoptive home study and any updates. So some of these adoptive parents probably were licensed maybe or went to an agency 5-6 years ago. They had an initial home study. We still need all of those updates to be included in the packet. In that packet of the adoptive home study, we need the current background checks. and the fingerprints, and that all has to be within a year. If those have been past a year, we will ask that you either have them review them, and that may delay. Most of the time it was just a matter of not being sent with a packet. We really haven't had that happen too often where they're not even current. If there's a order of appointment of legal guardian, we ask that that be included, and we also ask that for medical purposes, that the birth mother is providing an affidavit saying the adoptive parents have the authority to make medical choices for the child. Affidavit of expenses, this is probably new to some of you too that have done ICPC packets in the past. Many states are asking for this, so every state is different on that requirement. So Nebraska ICPC is just asking that it's in every packet because it will delay the process if we send a packet and then they say, oh, we need the affidavit of expenses. So if you have it at the get-go in the original packet, we can send it on and it doesn't delay the decision. The affidavit of expenses, Nebraska really doesn't have a lot of rules about that, but other states do. Florida is very strict on what they allow and not allow. So each state is different, and the other state will let us know if things on that expense document is allowable in their state. Copy of the sending agency's license, that is if you're working with an agency, they have to send a copy of their license just to verify that they have the authority to place a child. Biological parent information, that's the social history. If we do not have a social history, medical history, we will ask for that. I believe Susan has some of her documents in this booklet. That would be great information to include, and we will require that. Written statement from the entity that will be providing post-placement supervision. That is also needs to be documented on the 100A. We have had a couple of instances where if a foster parent, say they're an HHS foster parent, and they're licensed through an agency, but that agency is not licensed to do adoptions, they cannot do post-placement visitation. So we have to then go back and say they have to locate another agency or someone who will do post-placement supervision. So you may hear that every once in a while if we find an agency that's not approved to do adoptions. Now that can be a separate letter by the agency, or if they have just a general statement in their home study, that will work also. Authority to prospective adoptive parents to provide medical care, I already talked about that. Most common missing information from the initial packet is the medical risk statement from the adoptive parents. Again, we look at that. We want to make sure that those adoptive parents are aware of all the issues that the child may have or has been exposed to by an in utero. Letter confirming relinquishments are done correctly. That would be from you as an attorney. That's a new requirement, so we have been seeing that. Letter from agency to complete post-placement reports. If it's not in the home setting, we do need that. We will accept emails if that's easier. Child placing license, background checks, affidavit of expenses, and information about the father on how his rights will be dealt with. Again, it's that due diligence, it's the publication, it's the notice to vital records. We need all of that, so it's a complete package, so we know that the father's rights have been dealt with or being dealt with. Most common missing after placement, and I think once the child's been placed and they're moved and they're all in their happy home in that other state, this is kind of where it gets messy, because interstate compact, we cannot close any cases without official documents. So we will be hounding you for these documents because we have to just keep these cases open until we can determine if they've ever been adopted. We need the 100B. The 100B is another form that can be also found on the website. It is the form that shows that the child has actually been placed in that home and what day they were placed in that home. It's also, we need it at closure. So once the adoption's been finalized, we need the 100B to say it's been finalized, here is the decree. Receiving state and sending state, you can now officially close your ICPC case. We usually get post-placement visitation reports from the agencies. Agencies are very good about providing those, so that's usually not an issue. It's kind of hard to read. Placement in other states. What I really want you to keep in mind that you have to be patient because it goes through many layers before it gets the approval, because it'll come from you as an attorney, it will come to Mara, Leah, or myself, and then we look through the packet, and depending when we get the packet, if we can even look at it that day, because we may not get it until really late, or if you are the adoptive parent's attorney and the mail didn't get it to us until late, we may not have time to look at it that day either. So then we send it out to the other states. Now, this is the other thing that some attorneys have done. We send it however you guys want us to send it. So if you want it overnight, you need to send us a FedEx envelope to that other state so we can FedEx it overnight. If you do not provide that, we will send it regular U.S. mail. So it could take 2 or 3 days. So it's really however you guys want that packet to get to the other states. Then that goes to the ICPC office there in that state, and then they approve it. So depending on what their availability is that day, if they can look at it. Most ICPCs, infant domestic adoptions are priority, and we try to do it within 24 hours. So the bad thing is what I have found is when you're working with different time zones. So I may be able to approve something at 5 o'clock on a Friday, but if the family's waiting in Florida, if I don't have contacts after hours, they're stuck there for the weekend. So if you do have after-hour numbers, include that, or the parents' cell phone numbers, your cell phone number, so we can at least get them on the road if we do approve it. Because the approval doesn't have, if the child's coming here to Nebraska, I don't have to let Florida ICPC know if I'm approving it, especially if it's like after hours. I will let them know Monday morning that I gave my approval, and the parents have already been on their way because we were able to get hold of them. So, many states require different documentation. California is one of them, so always talk to those other states, find out exactly what documentation they need, especially if you're going to finalize the adoption in their state, or if they'll just, even in the ICPC packet, just a regular document that they may require that our statutes don't require. You just have to do your homework. And we may come back on the expense document too. If it is not detailed enough and the state needs that, we may have to ask you for more detailed information. And I already talked about the FedEx. Placements to New York, effective February of this year. On February 1st, New York is requiring a completed and fully executed adoptive placement fee disclosure form as part of their ICPC packet. So again, New York is asking for additional documentation. So it's just, again, doing your homework with that other state, finding exactly what their statutes are and what they are requiring. If you have any questions or need any forms, that is our email address. You can email us. It's a generic email, so Marlia, myself, Peg Barner, we look at that every day, so somebody will always be answering on that email on a daily basis. We also, Nebraska has been able to do some things electronically now, so it's called the NEED system. There's only, we're the 7 states that can do things electronically. So those states, such as Florida, District of Columbia, Indiana, Nevada, South Carolina, or Wisconsin, we send it electronically, and they can get it just like that, and they can approve it. So they're hoping that every state will go electronic instead of doing the whole mail situation. But states just have to be agreeable to that and get on board with that. But, and we should have put a list on that because like if you have adopted parents from Deanna, we can send it through me and they could get it within an hour. So it really shortens the time frame. Make sure that copies are legible when you send them to us because if we can't read them, we won't send them on. We need, this is probably one of the most time-consuming on our part. We need 5 copies of the 100A, but we only need 3 copies of the entire packet. The entire packet, the 3 copies, one stays at the Nebraska ICPC office, 2 get sent on to the other states. They then send one of those copies on to the agency that's going to do the post-placement visitation. So then these copies are with Nebraska ICPC, the receiving state ICPC, and who is doing post-placement visits. The 100As then, why we need 5, we keep 1, we send 4 to the other states, they'll send, and then they send us 2 back, so I can send them back to you. So that's it. That's why we need more of 100As, because it will then come back to you as the attorney. If you send more than 3 packets, they just get tossed in the garbage, and it's just a waste of resources on your part because they're just wasted documents. So we only need 3. What we would prefer is that 1 packet is together, not 3 of the same documents together. If you just have 1 complete packet here, we have 1 complete packet here, and we have 1 complete packet here. Because then what can happen, Leah can look at a packet, I can look at a packet, whoever looks at it soonest, and if we have questions, we can consult with each other, but it just helps. Instead of having everything all in one big pile, and then we have to sort it out. Any questions on ICPC? It can be very challenging, it can be very frustrating for both adoptive parents and as you, but if you really follow the checklist, it goes pretty smoothly.
How do you feel about piecemeal submission of packets, to send some of it and then follow up with some of it?
We will take it that way. It's, I think it's a little bit more challenging that way because I'm afraid documents get lost. I would prefer it all come at one time. Now, I know what some states and some attorneys prefer to do, so if they're for the adopted parents and they're helping get the packet together, but they know the birth mom's attorney down in Louisiana is getting a packet, they'll send a packet up to us before they get it to Louisiana. And then it gets confusing, like, okay, has it even been approved by Louisiana? Where is it at in the process? So it's okay if you send it to us, but it's not going to speed anything up because we'll wait for the other state to get approval.
What if you have a child that has to stay in the hospital for a while, you can't get a discharge summary? Should we send everything in ahead of time to get you to that point? Would you do a conditional approval? What do you do in that situation?
In that situation, we would, you could send us the packet. If you have any weird situations like that, always call us and talk to us. Because what we could do is do the initial packet. If everything's together except the discharge information from the hospital because the child's still there, we could call the other state and see how they feel about it. If they say, yeah, send us the packet, we could maybe give approval, provisional approval. At least maybe when if the child gets discharged over the weekend, they can head out instead of waiting for the other states to give approval. So a lot of states do work with us if we just talk to them and talk about situations. So it's really that good communication with the ICPC office, and then we can talk to the other state and see. One packet that we had gotten this year was they could not locate the father. They had not located the father, and the mother would not do a relinquishment or consent until they found the father. But they sent the ICPC packet, because the baby was born. They wanted the baby and the family to head to the other state. We talked to the other state about that because we did not feel it was an ICPC adoption at that point because there was no relinquishment, no consent for adoption. That other state would not approve it until there was a consent or relinquishment. So then they had to go back out, try to find birth mom and talk to her and see if she would do a relinquishment or consent. So any questions you have, you can always call us. We cannot give legal advice, obviously, because we're not attorneys. All we can do is kind of give you scenarios. We can talk to the other states, see what they would accept and not accept. And we do provisional up to 30 days on some situations. If you're the adoptive parents' attorneys and maybe an attorney down in the other state haven't gotten everything, we may do a provisional for 30 days, but those documents have to get to us. If not, then we'll have to deny the placement and the child will have to go back.
What if people cross state lines with the baby, do an adoption because they didn't know about the ICPC, and then they find out about that later? Did they ever send stuff to you for retroactive approval?
I don't think I've run into that.
What if you get a packet and the baby's born in Nebraska and birth mom's consented and she's identified 3 potential birth fathers and the attorney or agency didn't do anything to notify them? Would you give approval on that?
No. And I'm a big stickler on the father. So if there is no documentation whatsoever, I need publication. If you haven't published, just like Susan Sapp was saying, if you wait for that 9th month when the baby's been born and you're publishing and they want to head home, they're not going to be heading home because I won't even give enough approval to send it to the other state until that's been published and I have at least seen what it's going to look like in the newspaper and what dates those are going to run. Or if they've been notified, or so there has to be legitimate efforts to locate that father.
Even if it was going to be finalized under the receiving state's statutes, would you still require compliance with our registry and notice provision here?
Yes.
And if the publication isn't complete, meaning there's 2 more weeks to run and then they've got 5 business days after the last day of publication, would you accept an affidavit of legal risk from the parents where they would agree to bring the child back if there was a timely objection by the Birthfather in Nebraska?
Yes. And there might be you may have several different legal risks, even like ICPA, if there's some issues where, and we've had this happen too, where mom is an eligible member and because if there's any ICPA involved, I always take it to our legal to see what we should do to make sure we're at least working as a compliance. We may then come back and say, we want a legal risk from you as the attorney and have the adoptive parent sign and say, we understand the child could be eligible for ICPA or identified as an Indian child, so we know that as of this point, the tribes haven't been notified. There could be additional risks to this adoption, so we may come back with that.
So your legal risk statement should cover any unnotified birth father, unknown birth father, publication pending, medical conditions, in utero drug exposure, ICPA risks. Anything else? No. Is that about it? Okay.
I mean, we just want to make sure that the adoptive parents have been, just kind of what you were talking about too, that the adoptive parent has a clear understanding of what they're getting themselves into. Because we have had, and I think it was within the last year, where somebody was doing coverage for me and they allowed a baby to go and there was no efforts to locate dad. Dad showed up and they were upset with ICPC for even letting it go to the other state because we didn't, we knew, or at least the ICPC office who allowed it to go, knew that the father hadn't been identified. So the father then went and got the baby. So
there's been at least one case in Nebraska where the Nebraska ICPC person got sued.
Yes,
and
that was another situation.
Yeah, and
it was over a father issue.
Right. Yeah. So you don't ever want to get mad at these guys because they don't give approval because they've got as much responsibility to make sure it's done properly as you do. and to make sure that it can get finalized in the receiving state. It's no good getting it out of the sending state if you don't give the information that the adopted couple is going to need to finalize in the receiving state.
Because I think what I'm fearful of is once that birth mother's gone, she's gone. I mean, your time to get her and get the information is right when that baby's born, or shortly thereafter. And if you're waiting a month or two, and you may not be able to find her again.
Deanna, Kelly Tollefsen, and we worked a lot together. Never met you. Quick question. I had a Florida adoption, in fact, this week, where if birth mom does signs a choice of law provision agreeing to be governed by Florida's laws, and Florida's laws allow for consent to be signed at discharge rather than waiting the 48 hours. 48 hours or discharge. She was discharged prior to the 48 hours. I had her do the Nebraska consent, waiting the 48 hours, because in the past, ICPC's told me all the rights under Nebraska law need to be terminated regardless of whether or not she's signing a choice of law provision. What is ICPC's stance on that currently? Could I have taken the relinquishments at the time of discharge, and would Nebraska have accepted those with the choice of law provision?
I can't really answer that because I haven't had that come up. I would probably take it to our legal.
Okay.
But off the top of my head, if she has clearly signed, and you guys are the legal experts, I'm not, but I believe if she clearly signed a consent, and I understand I'm waiving all my rights here in Nebraska, and I'm doing it according to Florida law, and that's where the adoption is happening, I think we would let it go.
Thank you.
Any other questions? Thank you, Deanna. Our next presenter is Kim Anderson. Kim is the Pregnancy, Parenting, and Adoption Program Director of the Nebraska Children's Home Society. I've had the privilege of working with Kim for a number of years as she assists families and birth parents and adoptive families in the entire continuum of adoption. She does a great job, and if you need counseling, if you need support services for any of your clients, I would definitely encourage you to reach out to Nebraska Children's Home and partner with them in a way to provide full service and good service to all of our clients. So Kim is going to educate us about home studies and agency adoption. Thank you, Kim.
I'll try this and see. Did you just hold this? Can you hear me? You set it here, okay. Sometimes I like to move around, so hopefully I'll have to remind myself that I'm not moving around as I'm talking and lose this. But I want to thank Susan for inviting me to come and talk with you today about home studies in particularly, and what things that we need from you as agencies when we're the ones who are completing the home studies, what things are helpful, what things maybe are not as helpful, and so just to kind of be mindful of that. This one?
Is it on?
Oh. Oh, I see. Hold on. Okay, thank you. So just to kind of point out, and I'm sure all of you are already aware of this, but one of the things that is extremely important for us as child-placing agencies, and I'm going to go into the licensing part that we have to follow through the Department of Health and Human Services, bless you. Oftentimes what we run into is we will get requests from families and other agencies as well, not just the agency that I work for, but a lot of requests from attorneys from families who will say, we weren't aware that we needed a home study. We thought we only needed the background checks, and now we're being told we need a home study. So one of the things that I would just share with you about this is just to really be mindful of this when you're working with families and when you're encouraging them to reach out to the agencies that provide that service for them of the home study, to really make sure that they are doing that prior to the child being placed. And the reason that is so important is that we are only licensed to do pre-placement home studies. So if in fact a child is placed in a couple's home prior to that home study being completed and approved, and if the relinquishments or consents have been taken, the agency will be asking you for a court order. So just to make sure that that part of that is clear. And then we also are governed not only by Nebraska statutes, as you are, but we then have another set of standards that we have to follow as agencies, and these are the licensing standards for child placing agencies. They currently are going through some major revisions. They used to be maybe 5 or 6, maybe 7 pages. I think they're up where somewhere in the neighborhood of 60 pages now, that the first draft that we saw. And so I just want to also ask you to be mindful of that. These licensing standards really does dictate who can complete the home studies. Obviously, every state is different, but in Nebraska, it's only those agencies who are licensed as child placing agencies who can complete the home studies. As agencies, we are required to follow these standards. The actual standards, and in the new revision, these are even more spelled out in regards to what we're going to be asked to cover in the home study. It's very detailed in the new draft. It hasn't been yet approved, however, it will be better defined. It also is something, and I probably should have bulleted that second to last bullet up here, that we are required to do supervisions of placement. So if we do a home study, we really are required by licensing to do supervision of that placement if that placement still happens in Nebraska. So I know sometimes that's something where I think what can happen, and I do have a slide here shortly, that sometimes I think what happens for some attorneys, they will encourage their families to tell agencies to tell us that we don't really need those post-placement visits. They really do, because that puts us out of compliance with our license. And so we're responsible for that piece. So I'd really encourage you to be mindful of that. And I'll explain that in just a second too. So as I mentioned, the licensing standards are currently being revised. One of the major changes, and I'm really hoping that this will happen, is, and I know the other agencies that do similar work to what we do are hoping as well, there is a requirement that's proposed to have 16 hours of training that's not included in the home study process that families, individuals will need to go through in order to complete their home study. And so I know that's very different than the way we do it now. Agencies, typically when individuals or families, couples adopt your agencies, they do go through almost that amount, or if not more, training before they become approved. But this new requirement would also apply to families that you might be working with who would be having a home study completed, who will now be asked to complete, if it passes, an additional 16 hours of training. And I'm going to explain why that education is so important. The education is key during the home study process, and it's something that really helps families to get started off on the best foot possible. So in order to do the home studies, as all of you I'm sure are already aware, we have to be licensed in order to do voluntary placements. There currently are 7 agencies in Nebraska who are licensed to do home studies for the purpose of voluntary placement. Something that Deanna mentioned, and I thought, oh, this is good because she's laying the groundwork for me. Just within the last year, maybe a year and a half, would you say? Does that sound about accurate? The Department of Health and Human Services, particularly Children and Family Services, has now asked that those agencies who provide foster care, who now also are providing services to their foster parents or foster families to adopt children out of the foster care system, are now being asked to be licensed as an adoption agency too. And this is very different than just a few years ago. And the reason that this is important for all of you to know is that just because some of those agencies who do foster care, even though they may be licensed to do adoption, they are not licensed to do voluntary home studies. They are not licensed to do the post-placement supervision, as Deanna mentioned. They are only licensed to do the adoption piece, the home study piece, to do the home study for their foster parents in order to adopt a child out of the foster care system. So I know that the state and the agencies, we belong to a group called the Nebraska Adoption Agency Association, and this is something that has started to come up now because some families, not knowing better, and maybe some agencies not knowing better either, have gotten themselves into some messes where they've used agencies that truly were not licensed to do the voluntary piece. And so again, there are only 7 agencies that can do that, and so that would be something, and I can provide those agencies to Susan, and I'm sure she's very well aware of who they are too, but I can get that information and she can share that with you too. But I would really just want to caution you and make sure that families are speaking to the right agencies. So what is this home study? And if you have questions as I'm going through this, please feel free to ask me any questions. The purpose of the home study is not just to have families, have individuals complete a mountain of paperwork. Yes, there's a lot of paperwork that we have to collect. When you think about it, what we are doing is really preparing this family to become parents through adoption. Parenting through adoption is different. There are subtle differences, but there are differences than parenting a child born to you. And so the purpose of the home study really is to assess that readiness to become parents through adoption, and to provide education to that family. And the education piece is the piece that I would want to just stress and underline multiple times if I could, because it's not just the assessment piece, it really is talking to them about the issues that come into play when families adopt. One of the things that oftentimes our families don't like to hear, but we share with them anyways, is that adoption is built on loss, and adoption wouldn't exist if there wasn't loss. And so one of the key areas that we talk about are grief and loss, not only for birth parents, but for adoptive parents and for the child who's being adopted. So the amount of education that goes into this is extremely critical, and we are very fortunate here in Nebraska that the agencies that do the home studies, that are able to do them, are all very ethical and provide a lot of really great education to our families. So that's really the purpose, is to assess that readiness, to prepare them, to educate them, and get them on their way. The content of the home study, as I mentioned on the previous slide, really is set forth by our licensing standards. It has certain areas that we are required to go over. Those areas include things like getting information, talking to them about what it was like growing up in their family of origin. And oftentimes people will kind of laugh and kind of have a lot of questions about why do we need to talk about that? Well, one of the main reasons that we do that is even with best intentions, even with we may know better and we've learned from our own growing up years, we really do sometimes tend to parent the way that we were parented. Sometimes the things that maybe have happened in our childhood rear themselves up as we become parents. And so it's really important to talk about that. It's important to talk about how they were taught to develop relationships. And so all of that is in that background piece. We also will talk to them about their education background, their employment. We really do also take a hard look at finances. It's never about how much a family makes. And if you have a family saying to you, well, all they care about is how much money we make, and I would really encourage you to reach out to that agency and talk to them, because that's not our goal. But what our goal is when we are looking at the finances is making sure that families are able to provide for a child that their income, that they're able to manage the resources that they do have. One of the things that we have talked again in the group that the agencies belong to is probably in the last 8 years, maybe a little bit longer, we have seen a lot of families who have an incredibly high amount of credit card debt or unsecured debt. And so as agencies now, we really started to look at that because if you're having trouble managing your resources, your financial resources, even now in 2016, that is still one of the main reasons, leading causes for divorce. And so when we are looking at preparing families and approving them for the possible placement of a child, we want to be looking at those areas that we know that tend to cause divorces. Now that doesn't mean that adoptive parents somehow are exempt from divorce. It still happens. But again, that is an area that we really look at. Another area that we will look at is really how did they get to this path of adoption? That motivation. What's led them to adopt? One of the things that I would say definitely in the last couple of years, we've really been trying to talk to families about the fact that children who may be adopted, they don't need to be rescued. This isn't about saving kids. This isn't about rescuing kids. This is about finding families for children who need them. And so how did you get to this place of considering adoption? What led you to this, and how did you get here? We will also talk to them about their parenting philosophy, if they're parenting already or not, what that looks like. We also talk to them about different, their hopes, their dreams for children. One of the things that we also know in adoption is that sometimes the expectations that an adoptive parent has for his or her child has a strong indication of the relationship that they will have with that child. So sometimes these expectations that have no chance of being met up can sometimes set up that relationship for failure. So that's another area that we look at. We are required to get health histories. We are also required to have the family get a confidential medical report from a physician speaking to their ability to parent, speaking to their health, if there are any health concerns. Sometimes for families too, I know sometimes families will be concerned, well, maybe we've had cancer or we've had a transplant or maybe something else. And so what agencies will typically do in those situations is just have a release signed so that we can get more information. So just because you have had a serious illness or something that's happened would not necessarily rule a family out from being approved. The other pieces that we would talk to them are about their home, their community. We would also talk to them about resources available in their community, making sure they would know how to access different resources should a child need those. We would talk to them about their spiritual life, if they belong to a certain church or parish or synagogue, what have you. And then also we are required currently to get 6 references, and usually those are employer, personal, and for us it cannot be family. And then also we try to get a referral reference if possible. And then last but not least is our recommendation for that family, which I'll kind of hold on to for a second, but that's really the content of it. So in those appointments, we are required by licensing to have a minimum of 6 hours face-to-face with the family. And so I think to be safe right now, on average, it's probably closer to 8 to 10 hours for appointments. I would really, really caution any of you, if you have a family who says, oh, they came out and did it in one appointment. They sat here for 6 hours. Okay, that's not what a home study is. And if that's happening, I would really encourage you to maybe have them talk to another agency because that should not be happening. So the education and training also, so what that looks like then in the home study process is that agencies may be asking them to read books. They may be asking them to come to training. We ask any family that we work with to come to a 2-day training, and we actually won't release the home study until that's been done. But again, it's 2 days of training that they get to learn more about what it means to parent by adoption. And then also we may be asking them to come to groups, we may be asking them to, sometimes there's webinars, sometimes there's other opportunities for education, but that education piece is above and beyond the appointments. And so that's really important, I think, for all of you to know too, that if you sort of have this idea that it's you just come in, sit down, and we talk, it's not just that. Interestingly, in the new draft of the child placing standards, one of the requirements will be, if it passes, is that the appointments now have to be at a minimum a week apart. And I believe they also have increased the number of hours of that face-to-face that we have to have with them for the appointments. So again, helping them to understand that this is a process, it's not a one-time thing. The approval process will happen very differently in different agencies, but typically it's a supervisor or a program director that will review the home study, review the paperwork, and then you'll have the person who did the home study, and then typically a supervisor or a program director who will also sign off on that. Typically, in almost all of the agencies, that program director or supervisor is a licensed mental health practitioner, and so they have a clinical background too, which is really helpful when we're looking at assessing families and preparing them. So that's how that approval process would work. It's pretty typical too for home studies to take anywhere from 6 to 12 weeks. I know sometimes agencies will say that they'll do them quicker. I would really question what's going on in those home studies if they're saying they can get them done quicker. It's not a time clock. It's not how quickly can it be done. It's more important is that family having that opportunity to be prepared and also having the opportunity to receive education about adoption. A home study is only valid for 1 year, and the trigger that sets that time frame is the first background check. So whatever that first background check that was completed, whatever date that is, that's the trigger for when that home study would have to be updated. Checks, it could be the Nebraska State Patrol, it just depends on which background check, but that's the trigger. Something else that we've had happen a few times over the last few years is that sometimes families will think that they can use a home study that they've already finalized for a child, that they can use that home study now for another placement. That's not accurate. Home studies are written very specifically, typically in identified placements or designated placements. So if you're working with a family and they've been selected by a mom and that mom, dad placed with that family, that home study was written for that particular situation. So should another situation become available or another possibility, they would need a whole new home study. So it's not something where it's just you can keep using it. It's really not something that you should be getting an update on. It really does need to be a whole new home. That you would want to be able to have the agency assess and talk with them about.
When you have that situation where it's expired, though, is that just an update, or do they have to start fresh if you have more than a year past?
So the question is about if it's expired. It would depend on how long ago it had expired. So if you're talking it just expired in a few months, you could do an update. If it was over a certain number, like at our agency, if it's been over 2, maybe 3 years, we would do a whole new one. The trick is sometimes with the background checks and how long ago those were done too. And this actually is something that's being addressed in the new regulations about how far back you can go with it being expired before you have to do a new one. Because right now it's not clearly defined, but I would say for the last couple of years it would be okay. It's a good question. So one of the things that Susan and I had talked about is kind of, what are some of the reasons that an agency may not approve a family? And so I kind of started thinking about that, talked with some of the other agencies, and the number one thing that we kept coming back to is the number one reason that a family would not be approved is if they're not honest with us. I promise you we find out things. Even when families think we won't, we still do, and certainly I'm sure things have gotten by us. But it is so important for families to be honest with us. You know, I'm sure you've seen some of those crazy movies on Lifetime, sometimes crazy things in the news where they talk about, oh, you know, just don't talk about that, or just don't bring that up, or you need to talk to us about it. We actually now as agencies have, again, in our group of really focusing on best practices, our documentation does say now, should you not be forthcoming, truthful, share information, then that's reason for us to deny your home study or revoke the home study. And so I would just want you to know that so that you can encourage families that, you know, there may be things that families are really leery to talk to us about. Maybe there's a history of DUIs, or maybe there's a history of, you know, drug use or criminal behavior, things like that, maybe gambling, whatever the case may be. It's so much better to talk with us about it, because what we tend to do in situations like, let's say there's been a DUI, or there's maybe been some charges, you know, drug charges or what have you, we would really take a look at that and had individuals go and have gambling assessments completed. We're more about getting second opinions and making sure that we're not ruling families out. But the part that we really do have a hard time dealing with, or probably trying to wrap our mind around, is when people just completely don't share the information. There are, and I did not bring the list with me, but there is a pretty extensive list of criminal charges that if you were really interested in, I could get them for you, that would preclude us from being able to approve a family. Probably the number one thing is terroristic threats. We won't approve anybody if they've had a charge of terroristic threats. It used to be domestic violence, but now they would probably referred to as terroristic threats. This isn't funny, but it, you know, in the scheme of things, we had a situation many years ago where the family really just got so upset and we had documentation, you know, the police, and we had it, and it was, you know, clearly that was something that you can't overlook. So there are, you know, obviously certain things that would be, you know, we can't approve. The other thing that I would say, just a second, the other thing I would say, the second reason that we probably would either not continue to work with a family, not approve, or revoke a home study is if we found out that the prospective adoptive parents were giving money to mom prior to signing the consents or the relinquishments. It's a really gray area when you start talking about expenses that are appropriate under Nebraska statutes. They have to be related to the pregnancy. So yes, I know it's definitely a gray area, but I know for our agency, we have told families and have stopped working with families when we found out that they were giving money to a mom or to a dad. Because there's just no way to then not say that you couldn't use that as coercion or fraud, even the perception of. So that's something too that I know sometimes, I remember in one case, the family kept saying, well, our attorney said it was okay, our attorney said it was okay. Their attorney didn't know they were doing it. You know, when the rubber hit the road, it was really, no, we didn't know they were doing that. So they even removed themselves from the situation. So I think it's one of those things where those would probably definitely be the two main things. And then, like I said, the other one is there's just a pretty long list of criminal histories that we wouldn't be able to approve. Yes, sir, you were very patient.
Okay, so you said charged with terrorist threats. You mean just charged or convicted?
Convicted, I'm sorry. Yes, thank you for the clarification. Convicted, yes. Yeah, that's a pretty big distinction.
Kim, what about the issue of families who are still pursuing fertility options?
Oh, that's a great one. We would say that the couple needs to make a decision. It is really not okay in the realm of adoption to be pursuing fertility treatments and trying to go through an adoption as well. And the reason that we feel really strong, I feel really strongly about that, is that both of those avenues, both of those journeys take a lot of commitment, both physical and emotional. And I think oftentimes what it ends up saying from our perspective in working in the field of adoption is that this is your plan B. This is your backup plan. So if that doesn't work out, we'll go adopt a child. So then what does that mean for the child? You were our backup plan? You're less than? That's not what we want. And so that's why we ask people to choose one option or the other. Now, I do know that sometimes we run into families who even still now will have their doctor say, well, just go start the adoption process and then you'll get pregnant. That doesn't happen very often. It does happen sometimes. But again, I think it perpetuates this idea that it's a backup plan. And so we really want people to be mindful that you're either choosing to go down that road and choose that journey of trying fertility treatments, or you're going down and choosing the path of trying to become adoptive parents. The other thing I will say that we're really running into, and this might be, ask me in a couple years, but this might be a reason for not approving too. We're really running into some families who, they believe it to their core that children need to be rescued. And I know I mentioned that earlier, but sometimes what happens is that for those families, and that children need to be saved. And so what we're starting to see in some of those families is they don't value any type of relationship with birth parents. They don't see them as being valuable. They don't see them as being worthy. And so that, for us, is a big issue because adoptive parents do need to be able to see birth parents as valuable people and that they have a place in that child's life. So, but we're starting to see more and more of that happen. Yes. I'll let you go and then I'll have you go. Go ahead.
Are there age limitations?
There are age limitations for when couples are wanting to become part of a program at an agency. But if a couple came to us and asked us to complete a home study, depending on the age, we might talk to them. We would talk to them. Let's say if the couple was maybe in their mid to late 50s and they were talking about adopting a newborn, we would really talk to them about, okay, what's that going to look like when the child is 5? What's that going to look like when the child is this age? So I would say no. And the reason behind that is because when a mom and our mom and dad come to an agency and they say, this is the family that we would like to place our child with, we're going to honor that and respect that. But if we do have concerns or if we do see things that we need to talk about, we absolutely are going to have that conversation with everybody and put that out there on the table. Yes, ma'am.
My question was, and it may be specific, but just say that an adoptive couple was told by an agency that they were no longer, the agency was no longer going to work with them because they felt that they had given the bio mom money. Adoptive parents completely insist they didn't and never even found out really what the allegations were. That precluded them from working with any other agency, so they were just like done. They couldn't adopt them.
Well, I would say that would not be true in Nebraska. That just because if for some reason an agency said that they weren't going to continue to work with the family would not preclude them with working with other agencies.
Okay.
No. I've been doing this a long time, and again, I truly mean it when I say we are so lucky here in Nebraska to have really good people working in this field that just wouldn't happen.
I just know if there was any kind of an appeal process when somebody disputed that,
I would say there's probably more to the story.
Absolutely.
There's always more to the story.
Yeah.
And I think sometimes, I don't know what the rest of the story would be.
Right.
There's always there's always appeal process. Every agency has a grievance process, appeals process. Most of us, if not almost, I think all of us, but maybe 2 out of the 7. Set of standards and regulations, but good question. Good question. Okay, so those would be some reasons for not approving. So again, when you're talking to families, please don't tell families or share with families, well, it's just background checks. It's a lot more. It's really important. If you can really just help them understand it's not just one appointment, it's several appointments. One of the things I didn't mention, but would just also want you to know, is that one of the requirements through our child placing standards is that we are required to go to their home. And so again, it's not like we're looking for anything in particular, but we are asked to go to the home, and they're checking to make sure that their home would be suitable for a child. And I think the other thing is that sometimes we've heard from families where they sort of have this perception, and this could just be them, but sometimes they have this idea that it's really just a technicality. It's just a hoop they have to jump through. And the way that we look at it is it's something that's required, but it's also an opportunity for us to really provide a family with some great education and help to connect them to other families who also have adopted, and really hopefully get them off on the best foot possible. So if you, as attorneys, when you have families who are coming to you and maybe talking about the possibility of adoption, if you can just help to educate them about what that process is, why it's important. You know, if you believe in it and if you see the value in it, then they're going to too. And that's something that would be really helpful. If at all possible, if attorneys can refrain from taking relinquishments until that home study is completed and approved, that would be really helpful from an agency standpoint. And I know that may not always be possible, but again, just be mindful that if you're in a situation where that wasn't possible, the agency is going to ask you for a court order in order to do that home study. If all of you could also really support us when it comes to those post-placement reports, post-placement visits. We talk about this a lot in our Nebraska Adoption Agency Association meetings, where a lot of times attorneys may say to their families, you don't need them. They're right. It doesn't necessarily say that in the statute, but it does say it in the licensing requirements. And again, when licensing comes out to look at our paperwork, we have a home study, but we don't have the post-placement reports. We get asked, why not? So again, something that would just be mindful of. And again, I guess I would encourage you too to know that those post-placement visits, we're required to do 2 of them. Our agency does 3, but it's another opportunity to see how that child is doing, to see how they're adjusting to parenting, to see how the relationship with that birth family is going. It offers us opportunities to really support them and then to provide more education. And so again, it's something there to be support. It's not there to be critical, and when we're not trying to find something wrong. We're really there to be a support to the families. So how can we help you? We can definitely always open if you have questions or situations. You're always welcome to call myself, other agencies as well. Anytime you have education or anytime you want us to come and just talk about, an aspect of what we're doing, love to do that. Always enjoy the opportunity to share what we do. We also can take some of that, I don't want to say burden, but it may feel like that at times for you as the attorney working with the adoptive family. We can provide that education and support to the family. We can be the one up there at the hospital providing education support. We can be the ones they're calling and saying, okay, I'm feeling really nervous. I'm up, I'm down, I'm all over the place. What's going on? We can provide that education and support to them during that process and really throughout the process. We can also provide counseling services to parents who are pregnant, who maybe they just have their child, or maybe their child is just a few months old, maybe the child's a little bit older. But maybe for those parents who are considering placing their child for adoption, we can provide that counseling to parents to help them really look at the option of parenting and adoption and help get them the connections that they may need in order to make that decision that they think is best for their child. And when we do that, I know sometimes I think families in identified or designated adoptions really are fearful of having an agency involved because they're fearful that we'll talk them out of it or we're going to force them to choose a family within our agency. No, that's not what we're about. It's about making sure that every mom and dad who are experiencing an unplanned pregnancy have that opportunity to really learn about both options so that they can make the decision that's best for them. That's all that is. And so if that means placing with that family that they found, that's great. We're there to support them. And then really, when we work with families in our agency, and this is also true in placements where, maybe we've done the home study or only have done the home study, we really do see ourselves as resources for the rest of their lives. We tell people we're in this with you forever. We're partners with you. So we're there for the good, the bad, and the ugly. The other thing that I wish I would have remembered to include in here is that, have you heard of Right Turn before? It's a program between Nebraska Children's Home and Lutheran Family Services. Well, a year ago in December, so December of 2014, it's a state-awarded contract, and they actually expanded the services. So even for families now who've adopted privately through attorneys, are also eligible for those services. And so those are services available at no cost to families who have adopted. So just also would want you to have that information too. It's a wonderful resource, and we have staff actually across the state that provide that service. Oh, that's me. Any questions? Yes?
As a rule of thumb, how long does it usually take at home study from the time that they call you and tell that you've completed the first home study?
Well, there's a lot of pieces that go in between the appointments. The other thing that sometimes will catch us, it just depends sometimes on background checks, how far behind they are. Like I know right now, one of the checks is at least a month behind, and it just ebbs and flows. So that's, sometimes people don't get right on getting in to see their doctors. They don't tell their references that we're going to be contacting them. So a lot of times it can be a lot of factors. But if you go from the time they call till the time it's approved, I think that's probably a safe bet. Yes, ma'am.
What do you do in the event that you have an identified match outside of your agency and somebody contacts you and the birth mother's then due in 4 weeks, 5 weeks, 6 weeks, something like that? What would you recommend in that situation where there's no homesteading done, I guess?
I would say that, it would be up to whether or not if mom wanted baby to go home with the family or not. And if that was the case, then that
and then request the order from the courts to complete the post placement?
No, you don't need a court order to do the post placement reports. It's only if you take the relinquishments or the consent prior to the home study being done. Then that kicks it into, you have to have a court order for us to even do the home study or complete the home study.
Okay.
Yeah.
So it's not the placement, it's the consent.
Yes, it's the consents and relinquishments that set it, that kick it into a post-placement home study, which no one's licensed to do that. Yep. So in those situations, if attorneys can wait to take the relinquishment or the consent until after the home study is completed and approved, that's better. But if that absolutely can't be done, then you're going to need a court order to get that home study completed. And we're not trying, honestly, we're not trying to be difficult. It all goes back to our licensing.
We talked about that earlier, I think, before Kim got here, about going to the judge and getting a letter signed that says, I understand this homestead isn't completed, but mom can go ahead and place, and baby can go home with adopted parents pending the completed home study, and the agency has permission to do that, and it won't be a problem. We don't have a mechanism to actually go get a pleading that's a court order, but a letter signed by the judge has been satisfactory for the agencies we've done that with. Is that what you're talking about?
No, I'm talking about if you have the consents taken or relinquishments taken, we have to have a court order saying that you're asking Nebraska Children's Home to complete a home study.
Okay. That's,
yeah.
Maybe that, okay.
Yeah. So, but what we have seen happen in situations where people have come to us where they have identified a family and they just, let's kind of go back to what you said, Kelly, a situation where mom's due in 3 weeks, well, this is who I want to place with, and we're gonna work, all of us are gonna work with you at the agency, then that's on them if they're gonna take the baby home, and that's on them. And so really it's a babysitting type of arrangement. It's not an adoption. It's because nothing's been done. So because we can't be involved in that piece of it.
What would you say the percentage of approval is?
99? 99.9 probably. I mean, you really have to probably work at, and again, I think it really does go back to that not being honest piece.
Any other questions? Thank you, Kim.
Okay, thank you.
Educational. Thank you. Our next speaker is Kelly Tollefsen. And Kelly is a Lincoln lawyer who practices extensively in the areas of adoption law, assisted reproduction, family, custody, divorce, business, corporate, transactional, real estate, landlord, tenant, estate planning, probate, franchise law, criminal defense, civil, general civil litigation, and collections. She does it all. Kelly and I are both members of the American Academy of Adoption, or fellows in the American Academy of Adoption Attorneys. And Kelly is going to teach us about assisted reproduction primer and matters of birth certificates for intended parents, or AKA beyond the turkey baster.
really dealing with at that time only surrogates who are biologically related to the child. And then second, only compensated contracts. So the one law that we have on the books in Nebraska does not deal with our second way that we can have an artificial carrier, which is through the gestational carrier. And we know that it doesn't deal with non-compensated contracts. And so people have asked me what are the laws with respect, how are the case laws interpreted the statute with respect to surrogacy contracts. We have no laws that interpret this particular statute here in Nebraska. Most people that come to me nowadays are not looking for a traditional surrogate. They have a gestational carrier in mind, and that gestational carrier will either utilize the eggs of the intended mother or they will utilize the donor egg. And we'll either use the sperm of the intended father or use donor sperm. And sometimes we have donor egg and sperm. Sometimes we have an egg that's related to the mother, but donor sperm. We can have all different sorts of scenarios. But in most cases, we're not asking the carrier to provide her biological input in the making of this child. So what does the law state in Nebraska? We don't have any laws that pertain to that. So when people ask me, do we have a law against or defining that the contract's void and unenforceable with respect to gestational carriers? Well, no, we don't, because in 1987, when that law was created, we didn't have the medical technology that we do today to apply or to factor into that. We've talked a little bit about the definitions of what a gestational carrier is versus what a surrogate is. When people come to me and ask me, I have a surrogate in mind, she's my sister, or I have a surrogate in mind, we're going to use her egg, it's too expensive to get donor eggs, it's hard to get donor eggs, we want this specific genetic makeup of this child, we know that this person can supply those eggs. I always caution people with respect to that surrogacy thing, because we do have a contract saying that the rights that are a law saying that the rights that are established by that contract the rights of parentage in that contract, the court's not going to uphold that contract. And then what do we apply? Well, we apply the constitutional purposes, which indicate that the biological connection between the will supersede any other connection. And then we have the circumstance that that law tried to, I guess, do away with, which was determined to be against public policy, unrelated female and male ending up with the child and then fighting over custody of a child that's biologically related to both of them, but there was no relationship. And then we have another being the intended mother in as well, in a custody challenge. So that sort of thing I always caution people about, because I don't think it's a good idea, because the laws are very specific. However, if they were to come to me and say, you know, since it is a two-pronged test of that law, we have an uncompensated situation where we have a surrogate that's willing to grant her biological materials to us to produce a child, but we're not planning on compensating her, and the contract states clearly whose everybody's rights are. We've never had that case in Nebraska, but several states throughout the United States have upheld that contract and the rights as determined under that contract versus just that biological connection determining parentage. So generally I don't like that situation, it's sticky, but I think because there's no laws really governing it, if people choose to do it, that's fine, but they have to be aware of the risks associated with it, the fact that there are no laws or case law in Nebraska governing that statute, and know all the potentials. And a lot of times people they want to have a child. They have a situation that they think is right for them. You just have to make them aware that the issue on the law is uncertain at this time. There's no way I can tell you what may or may not happen in this case. If you choose to do it, that's fine. We'll create a contract that we think best establishes what you all want your rights to be, but I can't guarantee what the courts will do in the long run. So that's that situation. The situation we have a gestational carrier in Nebraska, and again, we have no case law establishing this, but it would be my position reading all the other states' laws and how they've interpreted that the law that was created in 1987, making it void against public policy, would not apply to a gestational carrier situation. And in a gestational carrier where she's not biologically related to the child, the rights as they're set forth in the contract would be determinative of parentage in the event that there is ever a dispute as to parentage once the child was born. And that's the way most of the states have read the laws, or have interpreted the laws that they have in their states. We still have 5 states that make gestational surrogacy, gestational carriers void against public policy, and not just surrogates, but actual gestational carriers. And we do have a couple of states that make it illegal, so that there's a criminal penalty attached to it if they choose to enter into an agreement. Nebraska is obviously not one of those. So when people come to me and want to prepare a gestational carrier contract, you first, and I attached one to the materials so that you have a copy of it. I would caution you, don't just use this contract blindly, because 2 things. There's 2 clinics that do the in vitro fertilization here in Nebraska, and they're both in Omaha. Both clinics require specific provisions in their contract. Anybody has this scenario that pops up, please feel free to call me and I can help you navigate through the doctors and that sort of thing. The doctors will have to review the contract. They require both parties to have an attorney, and that both parties attorneys indicate in a letter to the clinic that they've reviewed the contract with the carrier and with the intended parents. And the contract, like I said, I attached, these are real general provisions, but you want to outline in there who the parties are. If the gestational carrier is married, her husband should also be a party to the contract, because we know under Nebraska law, the husband of a wife giving birth is presumed to be the legal father. So he has some rights to this child as well that would be born as a result of this arrangement. So we would outline who the parties are, the gestational carrier, and then her husband, and then the intended parents are the persons wanting to have the child through the artificial technologies. And then, in addition to that, we want to set forth how they intend to have this, that this is a donor sperm used with a non-donor egg, or are we doing this in vitro fertilization? We want to set forth how this is done, because again, there's a lot of different scenarios how we can end up with a child. So I think each contract should set forth specifically donor sperm, non-donor sperm, donor egg, non-donor egg, so that at the end of the day, if there's any contract dispute, the gestational carrier couldn't claim that she didn't understand that this would not be a genetically related child to the intended mother, and claim some sort of parentage to the child, or not that it wasn't the child's best interest. So it's best just parties. The carrier has a Fourth Amendment right to privacy, and that means that regardless of what this contract says, she can do whatever she wants to with her body at any time during this pregnancy. The contract sets forth that if the gestational carrier chooses to abort the child, she can do that. That's her constitutional right to do that. And so both parties all need to know that that is something that laws has the ability to make certain determinations. The intended parents at least know what's out there, what's at risk, and what's at stake. And so it's very important to let them know. The contract should set forth the decision-making in the event of issues. So health risks to the child or health risks to the carrier. Ultimately, again, constitutionally, the gestational carrier is going to have the ability to make the end call, but your contract can come to a meeting of the minds of, what if there is a health issue affecting the child? Will you proceed with an amniocentesis? Will you proceed with more invasive health care procedures to help that child in utero? coming again to a meeting of minds. The more we can come to a meeting of minds, the less disputes we're going to have down the road. So we try to, formulate a contract that will deal with all of those things. What happens in the event that there's a health risk to the contract really sets forth those issues and has the parties just think of everything, because if they're not laid out there, people sometimes aren't thinking of all the different things that can arise during a pregnancy. The contract should set forth a number of embryos transferred at once. They should have a meeting of minds again of, we're going to transfer 3 embryos. Well, if you transfer 3 embryos, there's a possibility for 6 children or potentially more if those embryos split. And so they have to have an agreement before they hit that operating table of how many embryos will be transferred. The number of procedures that they can track to, a typical gestational carrier will agree to continue the contract for a period of 2 years or 2 procedures or sometimes longer. The gestational carrier contract will have a HIPAA release form that's signed by the gestational carrier so that the intended parents can get the information that they need from the doctor's office, and will have access to and from, or access to the doctor regarding any health information with respect to the child. And then it will have a compensation consideration if it is a paid gestational carrier situation. I will tell you that the clinics in Omaha do not allow for any sort of compensation to be written in the agreement. And so the agreements that they have don't have any formula of compensation or anything. If they agree on compensation, it has to be outside of what's in the written contract. And it can be a lump sum payment. I rarely see that. We'll pay you X amount of money at the end of gestation. It's typically monthly payments so that they agree on a specified amount that's paid out throughout the 9 months with a kind of lump sum at the end in the event that we have some sort of early birth. It provides typically that the gestational carrier's medical expenses, anything that's not covered by insurance, will be provided for by the intended parents. And then it has other things that can potentially be paid for, any transportation fees to and from doctor's offices, appointments, that sort of thing can be paid for. A lot of times these procedures take place in clinics outside of Nebraska, so flights to and from wherever they're going to happen. And then also hotel expenses, food expenses while they're gone, all those things are typically paid for by the intended parents. It deals with what happens in the event of early birth or the death of the fetus as far as compensation is concerned. What do we do in those situations? They typically say if the child has reached X amount of weeks in gestation, they are entitled to full payment pursuant to the contract, regardless of whether the child survives or does not survive. And then, like I said, different clinics have different requirements, so you have to know what your clinic's requirements are. What I found the best thing is that they require that you send the contract in for them to review. You send it in, and they tell you what they require, and you do whatever they require, because they're kind of holding the cards there, and there's no laws, unless it's something that's legal, but there's really no laws that really are coming into play. But they're typically in charge, and we do what they ask us to do because we know that they hold the cards in that sort of situation. The insurance coverage for the gestational carrying the child will be covered by the intended parents once the child is born. Their insurance, Nebraska law provides very clearly that a child, well, first of all, it's treated a lot like an adoption situation, but the child should be covered by the intended parent's insurance. The insurance coverage for the birth of the child and prior to birth has always been an issue with gestational carrier agreements, because a lot of policies will exclude gestational carriers. But if you look very closely at the policy, typically what the policy excludes and is talking to is not the maternity coverage for a gestational carrier, but payments made to a gestational carrier for having your child. So your insurance company is not going to pay that gestational carrier fee, but typically typical insurance policies won't exclude the pregnancy of a gestational carrier. There's no actual exclusion for if you're acting as a gestational carrier, we will not cover your pregnancy. If there are policies and insurance companies, I mean, they're trying to not cover these sorts of things. There's no way that a intended family can add the gestational carrier to their insurance company right now, but there are other gestational carrier insurance companies out there that specialize just in insurance for gestational carriers, but they are astronomical, and they're all based on risk, and you pay $10,000 up front as the premium, and then you pay additional dollars, and you're out that $10,000 whether you use the insurance or don't use the insurance. They're really astronomical and really only insure against a 3-month in the intensive care unit for an infant. So I don't suggest those to anyone. After the child's born in Nebraska, some states will have pre-birth orders is what they're called. So you can go in to your courts, your district courts, county courts, wherever they grant jurisdictions in the states that have pre-birth orders, and provide all the affidavits from the doctors indicating that the child is the child of the intended parents and not the child of the carrier and her husband. And the court will, if they're satisfied that this is not the carrier and her husband's child or just the carrier's child, will sign an order, which is then sent over to Vital Statistics, so that when that child's born, the names of the intended parents are placed on the birth certificate. Nebraska does not have that sort of statute. In 2007, I believe, we proposed legislation requesting Nebraska to consider a pre-birth order statute, but they refused to do so. Right now, we don't have any laws that allow that. So what has to happen now in Nebraska in order to get the intended parent's name on the birth certificate is any father's name can be placed on a birth certificate. So the intended father, whether he's biologically related or not, can sign an affidavit of parentage indicating that he is the father of that child and his name can be placed on the birth certificate. If the carrier is married at the time, there has to be what's called a 3-way affidavit signed by both her husband and the intended father, claiming that the intended father is the father of this child, and his name's automatically placed on the birth certificate, which precludes, like, if we have a situation where we have an adoptive or an intended family that's out of state that comes here for the birth, we wouldn't have to do the ICPC portion because we actually have an intended father that's listed on the birth certificate, and as a lot of times is the biological father. Unfortunately, the only person that can be placed on the birth certificate in Nebraska is that intended mother, or I'm sorry, is the gestational carrier gives birth. She signs a relinquishment and affidavit regarding non-consent form, medical history forms, and any other forms that are necessary for a step-parent adoption. And we take those, and 6 months down the road, the intended mother has to adopt, which can sometimes be her own biologically related child, through the court system. We get a report of adoption, we file that with Vital Statistics, and we get the actual intended parents' names both on the birth certificate in that way. And it's tough. It's really tough on intended mothers. I've had situations where the intended mother was biologically related, but her husband was not. He was automatically placed on the birth certificate. She had to adopt her own biological child, and she really struggled with that. I have other scenarios where same situation, but they just realize it's one of the hoops you have to jump through here in Nebraska because we don't have laws that govern this. So again, it's just very important in that sort of situation that you let them know up front that these are the hoops that you're going to have to jump through, and make sure that emotionally they're able to, realize that, yes, you're going to have to sit through an adoption proceeding of your own child, and are you going to be able to do that? So that 6 months down the road after the child's born, you're not just informing them for the first time, oh, by the way, we have to go through this other step. And I feel like the more you prepare them for what's going to have to occur, the better off they are. Okay, so I did attach, like I said, a copy of the gestational carrier agreement. Is there any questions any of you have? I feel like I ran through that pretty fast, but. I mean, bottom line on this is we just need a lot of legislation that will govern and deal with artificial reproductive technologies here in Nebraska. We don't have it, and so practicing this kind of law, you're kind of a pirate out there trying to figure out, how will this be interpreted? But people do this every day. Whether we have laws that are regulating this or not, they're doing it, and they're doing it here in Nebraska. And I mean, we do it the best we can, and we have to assure people that, here's where we think that the laws stand on this, but we don't really know. And so, like I said, it's just something that's very ripe for legislation right now. Yes. I've never had a problem, and I've had really good relationships between carriers and intended parents, except for one that they just were never meant to be together. I don't do any of the matching. There's a lot of agencies throughout the U.S. that does matching. The carrier has to pass psychological examinations. She also has to pass medical examinations. The intended parents, if they're using their own biological information, have to go through like 6 months of testing to assure that they're not HIV infected and those sorts of things. That sometimes can take 6 months in between tests to make a for sure determination. So I had one scenario. I had some kind of very uptight professors from California, and I had kind of this like hippie gestational carrier that liked to go to the dog park and be around big dogs, and she got bit by a dog, and the intended parents were very upset. And so that was the only time where it didn't flow very well, and I felt like we were at the hospital and we were maybe at a little bit of risk, not because gestational carrier wanted to keep a baby, but because everybody's just mad at each other. So again, I just tell people like to really have a good relationship with their gestational carrier too, and make sure that the lifestyles are somewhat similar, but I haven't had anything even close to bad since then. And that was years ago. And I have actually, there is an office in New York, Melissa Brisbane's office, that refers several clients from out of state to me for intended parents. And she will use sometimes, like I have one carrier that this is her 3rd time that she's carried, and she has 3 of her own children, lives in Omaha, enjoys being pregnant, enjoys the income from it, and then when I know I get that call, I know that I'm working with a carrier that's tried and true and tested and really enjoys this, and so it's, not difficult. Any other questions?
Thank you, Kelly.
Thank you.
Two sort of random thoughts. When we talked about ICPC earlier with Deanna, I wanted to mention to you that not going through ICPC and having a baby cross state lines without the necessary approvals is a misdemeanor, just by the way. And then also, Kim Anderson had referenced using particular agencies to get home studies. The home study law 43107 talks about, and the licensing regulations also talk about home studies needing to be done by licensed child placement agencies. Probably once every 2 or 3 years, I get somebody who has had a home study performed by a random MSW who's not affiliated with any licensed child placement agency. That is not a valid home study for purposes of adoption in Nebraska. So you need to be having your folks work with Nebraska Children's Home Society, Lutheran Family, Bethany Christian, Jewish Family Services, adoption consultants, Child Saving Institute, or Catholic Social Services. Did I forget anybody? Okay, I think that's all the licensed child placement agencies. The unique thing about adoption consultants is that they don't actually place children. They are licensed as a child placement agency, but they don't engage in the placement of children. They are very experienced social workers who previously worked for other placement agencies, but they just do home studies. They do a very nice job of them, so that's the one unique thing about adoption consultants. Okay, we are going to buzz through navigating the changing waters of step-parent adoption. We've talked quite a bit about some of the issues that are relative to step-parent adoptions, but I want to point out a few things as we're segueing off of Kelly's presentation. We now know that same-sex adoption will happen in Nebraska because same-sex marriage has been found to be constitutionally protected by the Obergefell decision from the United States Supreme Court. We know that that then changes the meaning of in re Luke, and everything has changed. So under 43-101, any adult person or persons can adopt, may be adopted by the spouse of such child's parent, but no person having a husband or wife may adopt a minor child unless the husband or wife joins in. So you can't have one person in a marriage be the only adopting parent. If they're married, they both have to join together, and two unmarried people can't adopt, but two lawfully married people can adopt regardless of gender. So we know that adult adoptions are affected as well. As we talked about earlier, step-parent adoptions are often more complicated because the children are older, there's more history, familial relationships, there's more chance for adjudication to occur, and the additional issue of determining assisted reproduction and the actual manner in which this child was conceived. So you need to be well versed in the language of assisted reproduction. Even if you never write an assisted reproduction contract like the one Kelly talked about, you need to understand the lingo because you need to know the questions to ask. So you need to know, was a child born by sperm donation? In professional gamete donation cases, sperm donation and egg donation, gestational carrier cases, in those professional conceptions that are assisted, you will be able to obtain documentation from the clinic as to who donated, not the identity, but that a donated egg was donated and that person who donated the egg waived all of their parental rights. Or sperm donation was made by sperm donor 921 and he was the source of this pregnancy and he waived his rights as part of his donation. An accredited clinic will always be able to give you that necessary documentation. You can't just go to court and finalize a step-parent adoption for a woman wife adopting her wife's biological child conceived through sperm donation by just coming in and saying, hey judge, it was a sperm donor. That's not going to be enough. You're going to need that documentation from the clinic that the clinic inseminated the wife who gave birth and that the sperm donor had waived his rights as part of that donation process. And we talked earlier, you've got to make sure that you know whether it was a professional donation or a homemade donation. You may have DNA in some cases, and we talked earlier about rebuttable presumptions in married parents. We talked earlier about the newborns and the putative father registry, the notice, all of that still has to be followed. So everything we talked about in terms of the importance of doing the interview, determining parentage, determining adjudication, other courts involved, all of that still applies. And it also still applies in same-sex step-parent adoptions as well, because sometimes the biological mom of a child whose wife is adopting the woman's child, the woman who gave birth was married to a guy at the time of that birth, so you've got to figure out what happened to that marriage, what happened to the former husband's wife situation. Just because the woman is now married to a woman doesn't mean she wasn't at some point married to a man, and you've got to track back through all of that parentage. Yes? We've done about a half dozen of those. Tami, have we done, what, 6, 8 of those since? We've done those. Yeah. We've done probably half a dozen of those. Yeah, you know, we can't even get Bureau of Health statistics to refer to the adopting parent as a legal parent. They're listed as father right now. So that's where we are. Getting Bureau of Health statistics to legitimate these children born in the term of the marriage, I'm not holding my breath. So when you have the same-sex partner adopting the other child's child, right now we've got to do them as a step-parent adoption, and I've decided not to beat my head against the wall trying to get BVS to do something I know that it won't do. And that's what you're talking about, is to go say, okay,
Then we just sit around and make these couples continue to do all of these expensive adoptions because we live in Nebraska. That's not okay.
I understand your concern, and if there was a shorter way to do it, I would do it. My experience has been they are so ecstatic to get to be able to provide some legal stability for these kids who have been in. I did a step-parent adoption for 2 women who got married last summer, who had been together for 27 years, and they had parented this 16-year-old every day of his life together. And we had to periodically do powers of attorney for the non-legal parent. And they're so happy to be recognized now as a family of 2 parents and a child. Yeah, the assisted reproduction folks that also feel like second-class citizens, the biological mom who has to adopt her own child, the adoption laws don't keep up with technology, and they don't keep up with changes in the social world. So we have to deal, because they're creatures of statute, we have to deal with them the way that they are. I'm not sure that we're going to see anytime soon a statute that will legitimize the parentage of those folks who were legally married and are same-sexed couples prior to Oberfeld. So I get your point. I'm just not holding my breath for it. So I haven't seen any legislation addressed to it, and I don't know how it would go over if it was. You know what I mean? So I'm always happy to have a solution when we have one, and the solution is to go in and do a step-parent adoption, even if they were married at the time the child was born. And right now, you'll get a birth certificate back that, irrespective of gender, will list, it has mother and father, and it might have 2 female names, it might have 2 male names, because that's just what it is. But I was afraid they weren't going to put their names on there at all, and we were going to have a big fight over that. So, all right, we already talked about adjudicated putative father, so I'm not going to repeat that section, but if you do a step-parent adoption and you have an adjudicated father, carefully read pages 3 and 4 of the outline. We talked about familial relationships. If you have a step-parent adoption and there's any sniff of a familial relationship, then read page 5. And then we talked earlier about married dads, married moms, and abandoning moms. In your handbook materials, in the main section of the manual, you may need to get substitute consent for an absent married parent. And that's under section 43-105 of the statute. The documents to ask for appointment of a guardian ad litem to give substitute consent are found in the manual. So even if you're doing a step-parent adoption, if you've got a married parent who is absent and an abandoning parent, you can't locate them to serve them, you're going to have to publish notice, you're going to have to send it their last known address, and you're going to have to ask the court to appoint a guardian ad litem to stand in the shoes of that parent to give substitute consent. So that's a whole other piece if you've got an abandoning mom or an abandoning dad. So be careful there. Last thing I want to say on step-parent adoptions is be cautious in connection with reimbursable expenses in a step-parent adoption. If you are having a step-parent adoption, let's say stepfather is adopting the child of stepmother. Stepmother was married to the child's dad, and he owes $40,000 in arrears of child support. He may be very anxious to sign. What I can tell you for sure is that in the month in which the decree of adoption is entered, you can let the court know, the court that handles the child support, let them know that an adoption has occurred and the date on which it occurred, and from that point forward, that parent will no longer have a child support obligation, because that child support obligation will end the month after the adoption of the child takes place. The gray area, and what many step-parent adoptions involve is a request by the biological parent, the married dad, who's the dad of the child at issue, wants his arrearage forgiven. There is a case, and it's in your outline, adoption of CLR, where the court held that agreeing to forgive arrearage was okay. That was in 1984. I would be very concerned with our current court as to whether or not they would uphold a relinquishment that was given in exchange for excusing multiple thousands of dollars of arrearage. It's a compensation, it's a benefit, it's remuneration in exchange for that relinquishment, and I would be very hesitant to do it. I'm not saying don't do it, because there's case law that says you can do it, just know you're doing it with a risk. And what I tell folks is don't make any agreement about the arrearage. If you want a receipt for it later, that's up to you, but don't make it a condition of the relinquishment. And it's a little bit cleaner that way. You'll see in the forms that are in this section of the step-parent adoption that the forms are more limited to what you're going to need for a step-parent adoption. You'll see the consent, the non-consent form. Non-consent form has nothing to do with consent. It's called it's a strange name. What it has to do with is explaining to the biological parent or birth parent that he or she has the right to file a piece of paper with file statistics. If they file that piece of paper, the child cannot see the original birth certificate of the child until the biological parent is dead. If you do nothing as a biological parent, the child can see his or her original birth certificate at age 21. The significance of that is the original birth certificate has the name of the birth mom, might have the birth dad's name on it, has their address at that time, and would be a good starting place for a birth parent search. So you have to explain that option to the birth parents, and then the non-consent form has the form attached that they could file to keep the child from seeing the birth certificate until they die. And you're simply doing your job of explaining that option to them. They don't have to choose it in that form, but you've got to document that you explain that option. You'll also see the interview forms that we talked about earlier, the birth mother interview, questions about the birth father. All step-parent adoptions have to have an affidavit of identification, even if it's simply biological parent was the husband of wife, and they were married and they got divorced, and he's the guy. You've got to have an affidavit of identification. And then you also need an affidavit of due diligence, even if you don't have to notify anybody because somebody's passed away. Then you better put in your affidavit of due diligence, biological father of this child passed away, here's his death certificate. Here's her affidavit of identification saying he's the guy, he's dead, we're done. So both of those forms are still needed all the time. A social history is not required in the statutes. A social history is required for an interstate adoption. I always use a social history. My brother was adopted in 1971. I helped him do his birth parent search when he was about 25 years of age. I learned so much from accompanying him through that search about what adopted kids need down the road. And in my brother's case, his biological father was deceased. He would have given anything to have a social history form filled out in his biological father's own hand with that information. I'm convinced that adopted kids, at some point, most of them want to know their story. They don't necessarily care what their story is, but they want to know. So having a social history in the hand, it was 25, 30 pages long. It's a beast. But it answers lots of questions that these kids might want to know. You know, are you right-handed or left-handed? What classes were you good at in high school? What did you enjoy? What kind of music did you like? Because they'll see something of themselves in there and say, oh, that's where I got that from. Oh, okay, I see what the relationship was. I guess my biological parents really did love me and want the best for me. They wrote this down. They did all this information. It tells them a lot of the answers that they need to know. So I make it mandatory that my clients do the social history. And I would encourage you to do that even though the statutes don't require it. And keep those documents. Do not get rid of your adoption files like you would in your ordinary document retention policies. Keep those files forever and keep them safe because they have irreplaceable documents in them. All right, and then when you are going to finalize an adoption, if you look in page 36 in that range of the manual, you'll see the forms you need to file, you'll see the costs that you need to pay, and you'll see the questions that you need to ask at a hearing on the finalization of an adoption, whether it's step-parent or two-parent or same-sex or not. The questions are basically the same. They're statutory and jurisdictional. Ask them, and that allows you to put in the proper evidence. Then last, understand that adoption court files are completely and totally confidential. You go and you do a finalization, and you complete the finalization, and the judge signs the decree of adoption. He or she then hands you the file, and you walk to the clerk's office with the file, and you give them the file, and you may never touch that file again. You can't. I could call the next day and say, can I have that file back? Answer, no. It's completely confidential. Adoptive parents can't see it. Attorneys can't see it. It is confidential. So what do you need to make sure you get out of it at the end of the finalization? You need to make sure that you get all of these certified copies of the decree that you're going to need for any purpose, and you need to get return of the original foreign documents in an international adoption that Tami talked about. So in the materials, there's an order that I have the judge sign at every hearing that I go to, especially in Lancaster County, that says, hey clerk, it's fine to give Sapp 6 copies of the certified decree, and please return the international original documents. Now, I go up to Douglas County, and they literally throw that away. And they say, how many do you want? We'll give you as many as you want. But it's one and only opportunity to get those certified decrees. So use a form if you think that it's necessary, or I would just use it, and if they throw it away, big deal, as long as they give you the certifieds. But that's your time to get them. So with that, any questions on step-parent adoptions? All right, next up is my dear friend and law school classmate, Karin Walton, who is going to give us tips on special issues in state ward adoptions. Karin is a practicing attorney in Lincoln, specializes in adoptions, wills, powers of attorney, estate probate, guardianship, conservatorship, divorces, and paternity and juvenile law. Welcome, Karin. Thank you.
Well, first of all, I just want to thank everybody that did present before me, because that was a wealth. They have a wealth of information. They made the adoption statutes, and especially Susan, made the adoption statutes so much better, and just so that we have more permanency in Nebraska with adoptions, and that's the goal of the foster care adoptions too. So I'm just thankful that we have so many good people working on adoptions in the state. I don't have lots of tips, but I do that haven't been already talked about. But I always, our biggest thing is the father, taking care of the fathers in a foster care adoption, because we kind of have a disconnect between the ongoing workers and the permanency workers. We're fortunate now that we do have permanency workers who just work on the adoptions and making sure that the fathers are taken care of and have a good packet for the adoption attorneys. But in the past, we've had a lot of issues where the ongoing workers didn't know what kind of notice they should give to the fathers, and whether there were fathers out there to look for the fathers. And the worst thing to have is a packet come to you, adoption packet come to you, and the fathers haven't been taken care of, and the child's been in the care of the family for, say, 2 or 3 years, and then you have to try to do due diligence to try to find those fathers, so that the adoption is an adoption that you can feel good about and that is a permanent option for the children. We've had cases where there have been fathers who had the DNA ran and everything, and they were found to be the father, but there was no order. And we had one particular case where this father had been trying to get a hold of the department and say, well, what happened to my DNA? And the packet had come to me to do an adoption, and then at the very last minute, the permanency worker found that there was this person out there that they had done a DNA on, and so then it prolonged the adoption another year, and luckily luckily for the foster parents who'd raised this child who was almost 2 years old and had a lot of physical difficulties. Where they went through the process in juvenile court of making sure that the father had every opportunity to to be the father for the child, and he was not able to do that. So the child was able to stay in the foster home and be adopted eventually. But those are nightmares you don't want to have to encounter when you have do a foster adopt, and that's the most important thing that we look at, or I am as an adoption attorney for foster parents, as that paternity issue and making sure that we have due diligence, or that the due diligence is done. I have oftentimes when the adoption packets come to us, the children have been through the juvenile court system for a year or two, and people want to have the adoption to go rather fast, and so they want to but you can't take any shortcuts. You can't take the shortcuts for the for publication. One time, a lot of my best practices have come because I've stumbled on a few things, and one of the times was I verified with the case manager that there was nobody on the affidavit of identification that the mother had identified as the father, and the caseworker said, no, there's nobody there. So, and we don't have anybody out there that is an alleged father. So I did a John Doe publish, and then I get the packet, and sure enough, on the affidavit identification, there was somebody listed. So we had to do a due diligence to try to find that person and to publish again. So I always, if they want to have a publication done before they give me the entire packet, I always want to have that due diligence. We want to have the affidavit of identification. And hopefully the due diligence has proper notice to any alleged father. I think that having the permanency team with the department has been a very beneficial thing for foster adoptions, and because these people work with all the regulations that should be in a packet, in an adoption that should be, that is helpful to making sure that that permanency option of adoption is fulfilled. We have some pretty experienced permanency workers, but there's a lot of caseworkers that are on the ongoing that who just don't have the training to know how to notify fathers, and hopefully the permanency team is working more with those caseworkers to make sure that they do have the proper they follow the proper procedures for finding the fathers and to giving them notification. When I meet with the parents, I always want to make sure that, I always want to make sure that that their subsidy has been talked about and is ready to be signed, because if you do an adoption without the subsidy, then you can't come back to get that subsidy implemented. And most of the foster adoptions that we have are subsidized, just because these are not always young children that they've been through the system, they've had abuse and neglect, and they have some trauma issues. So we're going to always want to make sure that that is something that we talk about when we meet to sign the petition. I always want to have make sure that if there's a communication and contact agreement, which is a part of a lot of the adoptions, that is something that they have possession of, or that they know who has possession of that communication and contact agreement, because you have to have that in your final decree. Thanks. I believe that those are the issues that we deal with when I meet with the clients, and I just, that's pretty much my best practices as a foster care adoption attorney. So.
Karin, how do you manage a birth parent client who is on the cusp of losing his or her rights to the child, wants to do an adoption, and has unreasonable expectations for what's put in a communication contact agreement?
Me as representing the client.
Yeah. How do you work with them to understand that it has to be approved?
Right. Well, you just have to have a reality check with them, because I mean, if you know that the termination is filed and your client wants to go through the trial or wants to relinquish, you just need to make sure that they understand that if they don't relinquish and there's a termination, then the department's it's going to be that much easier for there to be no reasonable efforts. And so you just have to, I guess you just have to work with the facts that you have. And generally people have ideas that you should have visitation every month, and that's not realistic. That's not an adoption. That's more like a parenting agreement. So we just have to have a reality check with your clients and make them understand that you're fortunate that the adoptive parents want to do a communication and contact agreement with you.
Have you ever had a judge refuse to approve an adoption based on what's in a communication contact agreement?
I haven't.
What if the birth mom wants to place for adoption with somebody other than the current foster parents? How does that work? Well,
they have to have the person that they want to have placed with. They have to go through. They have to have a home study done, and it's usually it depends on how long the child has been with the foster parents who are going to adopt. There's just a lot of contingencies, but generally they have to go through a home study, and then the judge has to decide then whether that placement change is in the best interest of the minor child. And oftentimes if the child's been with a party for a year or a year and a half, they're not going to change that placement, even if the parent wants that placement to go.
What's realistic in a communication contact?
Well, generally two times a year a visit, and pictures and letters. That's the most common one.
Do you sometimes have grandparents of the child be part of the communication and contact agreement?
You know, they can't be. I mean, they don't really have any rights after the parent relinquishes, and I mean they can be part. Sometimes it's written in there that the family members can be part of that visitation or with the child. Oftentimes they're supervised by the adoptive parents, though.
Karin, I just have a mechanical question. That I haven't done a foster adoption in a long time until recently, and when I went to court, it was a juvenile court one, where the juvenile court judge heard it, and she sort of indicated to me that most of the time people don't put the subsidy agreement into the court file. I had done that in the past. Is that what was the deal with that? Because I didn't quite understand what her issue was with it.
Well, I always put it in the decree if there's a subsidy, but I never put the subsidy agreement in the file. I have never done that. I don't know. So.
I guess I had attached it to my petition. You don't typically do that.
I don't.
Okay.
Because I don't usually enter into the subsidy agreements unless there is, there's a real issue of they should be, really they should really be putting more into the subsidy, but generally that's done between the department and the adoptive parent. So, hi, yeah.
I have a follow-up. As far as the subsidy agreement, you said that you put it into the decree. You write into the decree that the court approves the subsidy agreement?
Yes. There is, Susan has it in her forms, the language. I just use that language, and so that it is approved. Because a lot of times the adoptive parents have to have that language in there in order to get the adoption assistance through the IRS or whatever. That's why it's in there.
So then how does the court review it?
They don't.
How do they approve something you haven't reviewed?
No, they approve well, yeah, that's true. Well, good question, Dave, but, well, because it's an agreement between the department and the adoptive parents, I mean, they just, what the court approves is the fact that they entered into a subsidized agreement. That's all they approve.
It's more of an acknowledgement.
Yeah.
They approve the contents of the communication and contact agreement. They acknowledge the existence of the subsidy. I think I plead the special needs basis for the subsidy agreement, and they acknowledge the existence of it. Because I think for tax purposes,
right,
it's got to be in there. And I usually hear some pushback from the department about having it even mentioned in there, but they have to have it.
Right, it does. It has to be, yeah.
I was just going to mention one thing to keep in mind with the communication and contact agreement is, you know, the birth parent is doing this with the prospective adoptive parents. However, they're relinquishing to the department here within the
right.
case. So they're doing this communication and contact agreement, but it's not 100% guaranteed that that's who's going to adopt your child. So they need to know that yes, there's an agreement, but the child may not go to those people, and then you will not have contract agreement with another adoptive
right.
family.
And you should have that clause. I think you should have that clause in your communication and contact agreement also that says that. Yeah.
What order? What's the right order? Sign a relinquishment consent, and then do communication contact agreement, or vice versa?
I don't know.
Vice versa. You can't. They don't have any rights to sign an agreement if they've already relinquished. So you have to do the agreement first, then relinquish, then vote.
Is there any concern then about the McCormick contingent on you have made your consent relinquishment contingent upon retaining some parental rights? I mean, does the statute solve that problem, do you think, or?
That's what I've been told.
Well, and you know, I mean, the permanency worker that does take the relinquishments, I've sat in on quite a few of them. I mean, they do go through that. I mean, have you been promised anything? And really, the communication and contact agreement, I mean, I usually have in there the clause that the adopted parent has they have the final decision as to what is in the best interest of the minor child. So I think that, I don't think that, I don't know, I guess on that part.
I'll tell you, you get burned once.
I know, I know, yeah. Sorry.
I'm curious, have you had any Indian Child Welfare Act cases where the tribe is included as part of the agreement?
I haven't.
Their rights have not been terminated.
Right. I haven't.
Should that be best practices then?
Yes.
The child and the tribe should be consulted about the communication.
The tribe is a permanent part of that child's life.
Yeah.
And so some kind of agreement or understanding needs to be in place with the adopted family, cultural plan, et cetera.
I've seen a lot of cultural plans in place, but I haven't.
Those are still not enforceable.
No.
Under the Indian Child Welfare Act?
The cultural plan?
Yeah. You find an Indian Child Welfare child, and you have them adopted, and there's no involvement of the tribe will come back as an interested party and try to renew the whole thing because they weren't included.
Well, if the tribe has been part of the relinquishment on the record or the termination, isn't that?
But their rights are not terminated.
No, I know, but I mean, but they don't have a stake in it with that person, though.
Oh, yeah, that child is a member of their tribe. Permanently. I'm pointing it out because very seldom does anybody address it.
Yeah.
And if you have an Indian Child Welfare Act case, it is something that needs to be addressed.
I always address it in a guardianship, but
You go back long term and you research suicides among Native American children who have been removed from their families, and it's somewhere between 10 and 16 times higher than the average teenager. And that's because they've been denied connection and affirmation with their culture and that kind of thing. So,
ICWA compliance is a hugely important issue, and ICWA understanding sensitivity is very important. And we didn't cover it today because it takes about a half day or more to cover. And so be cognizant of it, know it's a specialty area,
It differs if you're dealing with an involuntary placement versus a voluntary placement. There's a brand new ICPA law that went into effect early 2015. Make sure you read that. And that's all I'm going to say.
Any more questions?
Thank you very much.